Comprehensive Industry Report. E-Commerce News Report May 3, 2026. 10 key e-commerce developments and their legal implications. Published, Sunday, May 3, 2026 Report Edition, Volume 2026, Number 18, prepared for informational purposes only. Warning disclaimer. Nothing contained in this report constitutes legal, medical, financial, or official advice. This content is journalistic news reporting and editorial commentary only. News is news, it is not legal, financial, or medical advice. Do not treat the following anecdotal stories, summaries, or commentary as professional advice of any kind. Always consult a qualified professional for legal, financial, or medical decisions. The authors and publishers assume no liability for actions taken based on the information presented herein. Executive Summary. Amazon posted record Q1 2026 earnings with $181.5 billion in net sales, up 17% YoY, while facing a California price-fixing lawsuit that produced damaging unredacted evidence in an FTC monopoly enforcement action that could reshape marketplace competition. Social commerce and platform competition intensified as TikTok Shop drove $4.9 billion in US Q1 sales. eBay's GMV surged 18% amid GameStop acquisition rumors, and E-TSE navigated AI search disruption, all raising novel legal questions around platform liability, consumer protection, and M&A regulatory review. Shopify's pursuit of nationwide money transmitter licenses and the emergence of agentic AI commerce signal transformative shifts in e-commerce infrastructure, triggering complex regulatory challenges across fintech compliance, AI liability, and autonomous purchasing frameworks. U.S. tariff upheaval, including the Supreme Court's landmark ruling that IEEPA-based tariffs are unlawful and the suspension of the de minimis exemption, fundamentally reshaped cross-border e-commerce economics, forcing brands to restructure sourcing, pricing, and compliance. Cybersecurity threats surged with supply chain attacks and AI-powered breaches escalating across e-commerce platforms, while the FTC's 2026 to 2030 strategic plan laid out aggressive enforcement priorities targeting privacy, data security, and platform accountability, creating a complex, multi-layered compliance environment for online retailers. Table of contents. Amazon posts record Q1 2026 earnings as e-commerce unit growth hits pandemic-era highs. California price-fixing lawsuit against Amazon. Amazon antitrust and FTC monopoly enforcement. Amazon seller data privacy and third-party marketplace liability. Amazon robotics and workplace safety litigation. Amazon AI investment and Anthropic stakes. Amazon advertising and consumer deception claims. Amazon delivery speed and independent contractor classification. eBay GMV surges 18% in Q1 2026 as GameStop acquisition rumors surface. GameStop potential acquisition of eBay. eBay Depot acquisition regulatory approval. eBay seller protection and platform liability laws. eBay DDoS attack and cybersecurity legal obligations. eBay tax reporting and 1099-K compliance. eBay authentication services and consumer protection. eBay climate transition plan and ESG disclosure requirements. TikTok Shop drives $4.9 billion in Q1 US sales as major brands join. TikTok's US legal status and potential ban. Social commerce consumer protection. TikTok Shop seller liability and product safety. TikTok data privacy and children's online safety. Social commerce tax collection and marketplace facilitator laws. TikTok affiliate marketing and FTC endorsement guidelines. Live shopping and consumer fraud prevention. E-TSE posts Q1 growth as AI-driven search reshapes the marketplace. E-TSE Depot sale to eBay. AI search algorithm transparency and seller fairness. E-TSE intellectual property and counterfeit enforcement. E-TSE seller employment classification. E-TSE data privacy and GDPR compliance. E-TSE consumer protection and return policies. E-TSE AI-generated product listings and disclosure requirements. Wayfair returns to active customer growth in Q1, outpaces home furnishings market. Wayfair product liability and furniture safety recalls. Wayfair sales tax and South Dakota v. Wayfair ongoing impact. Wayfair customer data privacy and security. Wayfair delivery and logistics worker classification. Wayfair advertising accuracy and price comparison claims. Wayfair physical store expansion and zoning/retail regulations. Wayfair international operations and cross-border consumer protection. Shopify pursues nationwide money transmitter licenses in fintech push. Shopify money transmitter licensing and state regulatory compliance. Shopify capital lending and consumer financial protection. Shopify payments and PCI DSS compliance. Shopify platform liability for merchant fraud. Shopify and sales tax collection. Shopify international data transfers and privacy. Shopify subscription commerce and auto-renewal laws. Agentic AI commerce emerges as the next frontier in online shopping. AI agent liability for autonomous purchases. Agentic commerce and antitrust. AI transparency and consumer disclosure. AI agent data collection and privacy. AI-generated product content and intellectual property. Agentic commerce and consumer fraud prevention. Open-source AI commerce protocols and regulatory frameworks. U.S. tariff upheaval reshapes cross-border e-commerce economics. Supreme Court IEEPA tariff ruling and Constitutional Trade Authority. De minimis exemption suspension and small business impact. Section 301 tariff compliance and customs enforcement. Cross-border e-commerce and international trade agreements. Tariff classification and product misclassification penalties. Import surcharge legal challenges and administrative law. Cross-border consumer protection and international returns. E-commerce cybersecurity threats surge as supply chain attacks and AI-powered breaches escalate. Data breach notification laws and e-commerce compliance. E-commerce PCI DSS compliance and payment security. Ransomware payments and legal implications. AI-enhanced cyber attacks and evolving legal frameworks. Third-party vendor and supply chain security liability. E-commerce platform liability for customer data loss. Cyber insurance coverage and e-commerce risk management. FTC consumer protection enforcement reshapes e-commerce privacy and platform accountability. FTC Section 5 enforcement against e-commerce deceptive practices. Federal privacy legislation status and e-commerce impact. Children's online privacy and COPPA enforcement in e-commerce. FTC negative option rule and subscription e-commerce. State privacy laws and multi-state e-commerce compliance. FTC endorsement guides and e-commerce reviews/testimonials. AI-driven personalization and consumer protection. One Amazon posts record Q1 2026 earnings as e-commerce unit growth hits pandemic-era highs. Amazon reported Q1 2026 net sales of $181.5 billion, up 17% year-over-year and 15% on a foreign exchange-neutral basis, marking the company's strongest quarterly revenue growth since the pandemic era. Earnings per share came in at $2.78, dramatically exceeding consensus expectations of $1.64 and reflecting the power of Amazon's diversified revenue engine. North America segment sales rose 12% to $104.1 billion, driven by robust consumer demand and accelerating Prime membership penetration. International sales climbed 19% to $39.8 billion, with particular strength in India, the Middle East, and parts of Europe. AWS revenue surged 28% to $37.6 billion, representing the fastest growth the cloud division has recorded in 15 quarters. Operating income reached $23.9 billion, compared to $18.4 billion a year ago, demonstrating meaningful operating leverage. Unit growth in the stores segment hit 15%, the highest level since COVID-era lockdowns reshaped consumer buying behavior. Amazon's advertising business crossed $70 billion in trailing 12-month revenue, establishing the company as the third-largest digital advertising platform globally behind only Google and Meta. The custom silicon chip business, including Trainium and Inferentia processors, topped a $20 billion revenue run rate, growing at triple-digit percentages year-over-year and challenging NVIDIA's dominance in AI hardware. CEO Andy Jassy highlighted unprecedented AI infrastructure demand during the earnings call, projecting $200 billion in total 2026 capital expenditures primarily directed toward data centers and AI compute capacity. Amazon has deployed over 1 million robots across its global fulfillment network since acquiring Kiva Systems, fundamentally transforming warehouse operations and delivery speed. The company delivered more than 1 billion items same day or overnight in 2026 so far, a logistical achievement that continues to raise the competitive bar for all retailers. JP Morgan raised its price target for Amazon to $330, implying approximately 28% upside from current levels. Despite the earnings beat, free cash flow decreased to $1.2 billion on a trailing 12-month basis, driven by a $59.3 billion increase in property and equipment purchases tied to the company's aggressive AI and cloud infrastructure build-out. Net income included a $16.8 billion pre-tax gain from investments in Anthropic, the AI safety company, which has seen its valuation soar over the past year. 5 major Wall Street firms raised their price targets following the report, with consensus maintaining a strong overweight rating. Amazon Studios' film Project Hail Mary grossed $615 million at the global box office, further validating Amazon's entertainment content strategy. Amazon's Leo AI assistant secured Delta Airlines as its latest enterprise client, expanding the assistant's footprint beyond consumer applications. The market is now watching closely whether Amazon's heavy AI spending will convert to sustained profitability or whether margin pressure will mount in the second half of 2026. Legal subtopics. 1.1 California price-fixing lawsuit against Amazon. California Attorney General Rob Bonta's price-fixing lawsuit against Amazon reached a critical inflection point in April 2026 when a court order resulted in the public release of previously sealed evidence on April 20. The unredacted filings allegedly show communications between Amazon and vendors as well as competitors including Target, Walmart, Chewy, Best Buy, and Home Depot, suggesting coordinated efforts to raise consumer prices across product categories. On April 16, 2026, the court denied Amazon's motion for summary judgment, allowing the case to proceed to trial and signaling the judiciary's view that there is sufficient evidence for a jury to consider. A preliminary injunction hearing has been scheduled for July 23, 2026, at which the state will seek to immediately bar Amazon from engaging in the alleged pricing communications. The trial itself is set for January 2027 in California's Superior Court, with potential nationwide implications if the state prevails. The specific vendor communications outlined in the unredacted filings detail alleged agreements on minimum advertised prices and coordinated promotional calendars. Amazon faces a potential injunction barring all forms of price communications with vendors and competitors, which would fundamentally alter how the company manages its marketplace pricing ecosystem. 1.2 Amazon antitrust and FTC monopoly enforcement. The Federal Trade Commission's ongoing antitrust action against Amazon focuses on the company's dual role as both a marketplace platform and a direct competitor to its own third-party sellers. Central to the FTC's case are allegations of buy-box manipulation, where Amazon's algorithms allegedly favor its own products or preferred vendors regardless of price or quality. The FTC contends that Amazon's seller pricing policies, including punishing sellers who list products at lower prices on other platforms, constitute illegal monopoly maintenance. The case draws on internal documents reportedly showing Amazon's awareness that its practices harmed consumers and suppressed competition. Legal scholars note that this case could establish precedent for how antitrust law applies to two-sided digital platforms, potentially extending to other tech giants operating marketplace models. Amazon's defense centers on consumer welfare, arguing that its practices ultimately deliver lower prices, faster delivery, and superior selection. The outcome will likely shape e-commerce competition policy for the next decade, with implications reaching far beyond Amazon to every major platform marketplace. 1.3 Amazon seller data privacy and third-party marketplace liability. Amazon's use of aggregated and individual seller data to inform its own private label product decisions remains a focal point of both regulatory scrutiny and civil litigation. The European Union's Digital Services Act, DSA, imposes specific obligations on very large online platforms, including Amazon, to provide transparency about how seller data is collected, used, and shared across business units. Third-party sellers have filed class action lawsuits alleging that Amazon mines their sales data, pricing strategies, and customer reviews to develop competing Amazon Basics and private label products. Product liability is another growing legal exposure. Courts in multiple jurisdictions are reconsidering whether Amazon qualifies as a seller under product liability statutes when it fulfills and delivers third-party goods through FBA. The EU's Digital Markets Act further designates Amazon as a gatekeeper platform, subjecting it to data portability requirements and prohibitions on self-preferencing. Amazon faces a patchwork of U.S. state laws on seller data privacy, with California's CCPA granting sellers rights to know what data is collected and request its deletion. The convergence of these regulatory frameworks creates a complex compliance landscape that requires Amazon to fundamentally restructure how it handles the data generated by millions of third-party sellers. 1.4 Amazon Robotics and Workplace Safety Litigation. OSHA investigations into Amazon's warehouse operations have intensified following reports that injury rates at robotics-equipped fulfillment centers exceed industry averages by significant margins. Multiple lawsuits filed by warehouse workers allege that Amazon's algorithmic productivity tracking systems create unsafe working conditions by penalizing workers who slow down to avoid injury. The deployment of over 1 million robots has transformed labor requirements but also introduced new categories of human-robot interaction injuries that existing OSHA regulations were not designed to address. State-level regulators, particularly in California and Washington, have enacted or proposed Amazon-specific warehouse safety quotas legislation requiring disclosure of productivity metrics and injury rates. The legal question of whether automation-driven worker displacement constitutes a compensable harm under existing labor law is being tested in several jurisdictions. Amazon's defense emphasizes that robotics have eliminated the most physically demanding tasks and that overall injury rates have improved, though critics argue the data is selectively presented. The evolving case law around warehouse automation safety will likely establish standards that apply across the entire e-commerce fulfillment industry. 1.5 Amazon AI investment and Anthropic stakes. Amazon's $16.8 billion in unrealized gains from its Anthropic investment raises significant questions under securities law regarding the proper treatment and disclosure of strategic AI stakes in quarterly financial reporting. The FTC has signaled interest in reviewing big tech companies' investments in AI startups, particularly where those investments could confer competitive advantages that reduce market competition. Antitrust scholars argue that Amazon's deep financial integration with Anthropic combined with AWS hosting Anthropic's AI models creates a vertical integration dynamic that regulators have historically challenged. The SEC's evolving guidance on how companies should disclose unrealized gains from private investments affects how investors interpret Amazon's earnings quality. Legal experts note that if Amazon's Anthropic investment were classified as a controlling interest, it could trigger additional regulatory requirements under Hart-Scott-Rodino and other merger review frameworks. The broader pattern of big tech companies investing billions in AI startups including Microsoft OpenAI and Google Anthropic relationships is generating calls for new regulatory frameworks specifically designed for AI-era partnerships. Amazon must navigate these overlapping securities, antitrust, and technology regulations while ensuring its AI investment strategy continues to deliver competitive advantage. 1.6 Amazon advertising and consumer deception claims. The FTC has increased scrutiny of Amazon's advertising practices, particularly the blurring of lines between organic search results and paid sponsored placements on the Amazon marketplace. Consumer advocacy groups have filed complaints alleging that Amazon's sponsored product placements constitute dark patterns, designed to make advertisements appear indistinguishable from organic product listings. The FTC's updated endorsement guidelines require clear and conspicuous disclosure when search results are paid placements, a standard that critics argue Amazon does not consistently meet. Internal studies reportedly show that a significant percentage of Amazon shoppers cannot distinguish between sponsored and organic results, raising questions about whether current labeling satisfies FTC disclosure requirements. Amazon's advertising revenue model, which now exceeds $70 billion annually, creates financial incentives that may conflict with consumer protection obligations. The company faces potential class action exposure from consumers who allege they purchased higher-priced sponsored products when cheaper alternatives were available but suppressed in search results. Regulatory intervention could require fundamental changes to how Amazon displays advertising, potentially impacting a business unit that has become central to the company's profitability. 1.7 Amazon Delivery Speed and Independent Contractor Classification. Amazon's Delivery Service Partner, DSP, program, which uses contracted small businesses to handle last-mile deliveries, faces escalating legal challenges over whether drivers are effectively Amazon employees entitled to benefits and protections under federal and state labor law. Lawsuits in California, Massachusetts, and New York allege that Amazon exercises sufficient control over DSP drivers' routes, schedules, uniforms, and performance metrics to establish an employment relationship under the ABC test and similar standards. The Department of Labor's 2024 Independent Contractor Rule, which narrowed the definition of independent contractors under the Fair Labor Standards Act, has complicated Amazon's DSP legal defense. Drivers have alleged that Amazon's algorithmic routing systems and delivery quotas create conditions indistinguishable from traditional employment, including penalties for missed delivery windows and requirements to work specific shifts. The economic implications are substantial. Reclassification would require Amazon to provide minimum wage guarantees, guarantees, overtime pay, health insurance contributions, and unemployment insurance for hundreds of thousands of drivers. Amazon argues that DSP owners are independent businesses that make their own hiring, firing, and compensation decisions, and that the DSP model provides entrepreneurial opportunities. Multiple state attorney general offices are investigating the DSP model, and a nationwide class action certification ruling is pending that could determine whether these claims proceed collectively or must be litigated state by state. eBay GMV surges 18% in Q1 2026 as GameStop acquisition rumors surface. eBay reported Q1 2026 revenue of $3.1 billion, up 19% year-over-year, significantly exceeding analyst expectations and marking the company's strongest quarterly growth in over a decade. Gross merchandise volume reached $22.2 billion, up 18% on a reported basis and 14% on a foreign exchange neutral basis, driven by strength in refurbished electronics, collectibles, and parts and accessories. GAAP earnings per share were $1.12, while non-GAAP EPS reached $1.66, both beating consensus estimates. Operating margins were 19.8% on a GAAP basis and 29.4% on a non-GAAP basis, reflecting disciplined cost management and a favorable revenue mix. The company generated $970 million in operating cash flow and $898 million in free cash flow, providing substantial capital for strategic investments and shareholder returns. eBay returned $639 million to stockholders through share buybacks and quarterly dividends during the quarter. The company was recognized by Fortune, Newsweek, and Time for innovation and sustainability leadership in the e-commerce sector. eBay entered an agreement to acquire Depot from ETSE in February 2026, a deal subject to regulatory approval that would strengthen eBay's position in the growing second-hand fashion and Gen Z marketplace segment. The InkFrog listing management tool owned by Wix announced its permanent shutdown effective June 2026, creating significant operational turmoil for thousands of eBay sellers who relied on the platform for multi-channel listing management. Persistent rumors have circulated that GameStop, flush with capital from its cryptocurrency treasury strategy, may make an offer to acquire eBay entirely, though no formal bid has materialized. eBay experienced a major platform outage in late April that lasted several hours and disrupted millions of active listings, with some reports suggesting the incident may have been related to a distributed denial-of-service attack. The platform appointed Brian Sharples, the founder of HomeAway, to its board of directors, adding expertise in marketplace business models. eBay released its inaugural climate transition plan, targeting net zero greenhouse gas emissions across all scopes by 2045. eBay for Charity raised nearly $60 million in Q1 alone, underscoring the platform's community engagement. Q2 2026 guidance projects revenue of $2.97, $3.03 billion and GMV of $21.3, $21.7 billion, representing 8 to 10% foreign exchange neutral growth and suggesting continued momentum though at a more normalized pace. The pending Depot acquisition strategically positions eBay in the rapidly growing resale and recommerce market, which industry analysts project will exceed $100 billion globally by 2028. Competition from TikTok Shop's live commerce features and Amazon's expanding refurbished goods program remains intense, requiring eBay to continuously innovate on buyer and seller experience. eBay's investment in AI-enhanced search, computer vision authentication for luxury goods, and natural language listing tools is differentiating the platform in categories where trust and expertise matter most. The company declared a quarterly dividend of 31 cents per share, payable June 12, 2026, to shareholders of record as of May 15. Sellers across the platform are adapting to new listing tools and workflows following the InkFrog closure, with eBay offering migration support and promoting its native seller hub capabilities. Legal subtopics. 2.1 GameStop potential acquisition of eBay. The rumored GameStop acquisition of eBay would face significant regulatory hurdles, beginning with mandatory Hart-Scott-Rodino Act filings with the FTC and DOJ Antitrust Division, given the transaction would far exceed the $111.4 million reporting threshold. Any hostile takeover attempt would trigger eBay's shareholder rights provisions, potentially including a poison pill defense that would dilute the acquiring company's stake. The legal framework distinguishing hostile from friendly takeovers would determine GameStop's available strategies, including tender offers, proxy fights, or negotiated mergers. FTC antitrust review would examine whether combining GameStop's gaming retail presence with eBay's marketplace would reduce competition in the collectibles, used games, and consumer electronics categories. Market manipulation concerns arise from the fact that GameStop's stock price has historically been subject to coordinated retail trading activity, raising questions about whether acquisition financing would rely on volatility-driven capital. Securities law requires GameStop to file Schedule 13D disclosures once it acquires more than 5% of eBay's outstanding shares, providing public notice of its intentions. The legal complexity and regulatory timeline for a transaction of this magnitude would likely extend 12 to 18 months from any formal offer to closing. 2.2 eBay Depot acquisition regulatory approval. The eBay Depot acquisition requires approval from multiple regulatory bodies given Depot's significant user base in the United Kingdom and European Union, triggering review by the UK Competition and Markets Authority, CMA, and the European Commission. Cross-border M&A compliance requires eBay to demonstrate the transaction will not substantially lessen competition in the resale fashion and second-hand goods markets in any relevant geographic area. EU competition authorities will examine whether the combined entity's market share in recommerce exceeds thresholds that would trigger Phase 2 in-depth review. Data transfer implications under GDPR are significant because Depot's European user data currently flows under ETS's data processing agreements, which must be renegotiated under eBay's privacy framework. The deal requires regulatory sign-off on how user accounts, purchase histories, and payment information will be migrated between platforms in compliance with data minimization principles. UK post-Brexit competition law operates independently of EU merger review, potentially imposing different conditions or remedies on the transaction. The regulatory approval timeline creates uncertainty for both Depot sellers and investors, as any extended review period could delay integration benefits and competitive positioning. 2.3 eBay Seller Protection and Platform Liability Laws. Section 230 of the Communications Decency Act has historically shielded eBay from liability for content posted by third-party sellers, but recent judicial decisions have narrowed this protection when platforms exercise editorial control over listings or make specific product recommendations. The proposed ShopSafe Act would impose contributory trademark liability on online marketplaces that fail to implement adequate brand protection programs, requiring platforms like eBay to vet sellers and screen listings for counterfeit goods. Seller disputes over eBay's resolution processes have generated litigation alleging that the platform's buyer protection policies systematically disadvantage sellers, particularly in cases involving false, item not as described, claims. Courts in several states have found that eBay may qualify as a seller for product liability purposes when it processes payments, handles returns, or promotes specific listings through advertising. The platform's money-back guarantee program creates contractual obligations that can be enforced under state consumer protection statutes, potentially exposing eBay to claims beyond its standard terms of service. International seller protection varies dramatically, with EU consumer law imposing stricter obligations on platforms that facilitate cross-border sales. eBay must balance robust buyer protection with fair seller treatment to maintain marketplace integrity while minimizing litigation exposure across multiple jurisdictions. 2.4 eBay DDoS attack and cybersecurity legal obligations. The late April platform outage, potentially linked to a distributed denial-of-service attack, triggered data breach notification obligations under state laws that require disclosure when customer information may have been compromised during a cybersecurity incident. All 50 U.S. states plus the District of Columbia have enacted data breach notification laws with varying requirements for timing, content, and regulatory reporting. eBay's terms of service include service-level provisions but typically disclaim liability for outages beyond the platform's reasonable control, a defense that applies differently depending on whether the outage resulted from an external attack or internal system failure. The FBI's Internet Crime Complaint Center, IC3, typically becomes involved in investigating DDoS attacks that cross state lines or cause damages exceeding federal thresholds, potentially classifying the attack as a federal computer crime under the Computer Fraud and Abuse Act. Sellers who lost sales during the outage face the challenge of quantifying damages and demonstrating causation, particularly for time-sensitive auctions that expired during the disruption. Cybersecurity insurance coverage for DDoS-related losses depends on whether the policy classifies such events as security incidents or business interruptions, a distinction with significant coverage implications. eBay's obligation to maintain reasonable cybersecurity measures is evaluated under an evolving standard that regulators and courts are continually updating in response to new threat landscapes. 2.5 eBay tax reporting and 1099-K compliance. The IRS lowered the 1099-K reporting threshold from $20,000/200 transactions to $600 with no minimum transaction count, effective for tax year 2025, fundamentally changing the tax reporting landscape for millions of casual eBay sellers. This threshold means that individuals selling personal items from used clothing to household goods now receive tax forms that previously only applied to high-volume commercial sellers. State-by-state variations add complexity, as some states have adopted thresholds even lower than the federal level, while others conform to the old or new federal standard, creating a patchwork of compliance obligations. eBay must collect and verify seller tax identification information, typically SSN or IN, before processing payments, and failures in this process can result in backup withholding at a 24% rate. Sellers face the burden of distinguishing taxable income from non-taxable returns of capital on personal items sold at a loss, documentation requirements that many casual sellers are unprepared to handle. The IRS has acknowledged the confusion caused by the new threshold and provided limited transitional relief, but the fundamental reporting obligation remains in effect. eBay provides tax reporting tools and educational resources, but legal responsibility for accurate tax filing ultimately rests with individual sellers, many of whom may face unexpected tax bills or audit exposure. 2.6 eBay Authentication Services and Consumer Protection. eBay's Authenticity Guarantee Program, which provides third-party authentication for luxury watches, sneakers, handbags, and trading cards, creates legal liability for authentication errors that can result in consumers paying premium prices for counterfeit or misidentified goods. When authentication fails, the legal question of responsibility becomes complex. eBay may be liable under state consumer protection statutes for negligent misrepresentation, while the third-party authenticator may face independent claims for professional negligence. Warranty implications arise because eBay's authentication stamp creates an implied warranty of authenticity that may exceed the protections available for non-authenticated purchases, potentially extending eBay's exposure under the Magnuson-Moss Warranty Act. The authentication process involves physical inspection, which creates bailment obligations. eBay and its authenticators have a legal duty to protect items in their possession from loss or damage. Fraud prevention obligations under the authentication program require eBay to maintain systems that detect and prevent the submission of known counterfeit goods, a standard that evolves as counterfeiters become more sophisticated. Consumer remedies for authentication failures vary by jurisdiction, with some states allowing treble damages under consumer fraud statutes while others limit recovery to actual economic harm. eBay's authentication services represent a significant competitive differentiator, but the legal obligations they create require robust quality control and dispute resolution processes. 2.7 eBay Climate Transition Plan and ESG Disclosure Requirements. eBay's inaugural Climate Transition Plan targeting net zero emissions by 2045 coincides with the SEC's finalized climate disclosure rules, which require public companies to report material climate-related risks and greenhouse gas emissions in annual filings. The SEC rules currently subject to legal challenges in federal court would require eBay to disclose Scope 1, direct, and Scope 2, energy-related, emissions, with Scope 3, supply chain, emissions disclosure provisions that are particularly complex for marketplace platforms that facilitate rather than produce goods. Greenwashing litigation risk is significant. If eBay's climate commitments are perceived as misleading or unsupported by concrete action plans, the company could face shareholder suits, FTC enforcement actions, or state attorney general investigations under consumer deception statutes. California's Climate Corporate Data Accountability Act, SB 253, requires large companies operating in the state to report all three scopes of emissions, imposing obligations that may exceed the SEC's requirements. eBay's Scope 3 emissions reporting is uniquely challenging because the platform facilitates transactions in used and refurbished goods, which arguably reduce net emissions compared to new product purchases, creating both a sustainability advantage and a complex accounting challenge. ESG rating agencies evaluate companies like eBay on the credibility and specificity of their climate transition plans, and downgrades can affect institutional investment flows and capital costs. The legal landscape for climate disclosure is evolving rapidly, with new state laws, international standards, ISSB, and European directives, CSRD, creating overlapping compliance obligations for globally operating e-commerce companies. 3. TikTok Shop drives $4.9 billion in Q1 U.S. sales as major brands join. TikTok Shop generated $4.9 billion in U.S. sales during Q1 2026, nearly doubling year-over-year volume and establishing the platform as the dominant force in American social commerce. The platform now accounts for roughly 20% of all U.S. social commerce sales, a market share that has grown dramatically from single digits just 2 years ago. Major brands including Ralph Lauren, Ulta Beauty, Olaplex, and Samsung have launched dedicated storefronts on TikTok Shop, lending mainstream credibility to a channel previously associated with impulse buys and viral novelty products. TikTok Shop's native conversion rate of 4.7% surpasses Instagram Shopping at 3.1% and Facebook Shops at 2.8%, reflecting the platform's superior ability to translate engagement into transactions. Live shopping events on TikTok generate 10-15x more engagement than static posts, creating a dynamic sales environment that blends entertainment, community, and commerce. Sales from big-name brands with over $30 million in annual revenue increased 97% year-over-year on TikTok Shop, demonstrating that the platform has transcended its early adopter phase. The platform drove $500 million in sales during the Black Friday to Cyber Monday 2025 period alone. U.S. social commerce has officially surpassed $100 billion in annualized sales volume during 2026, with TikTok Shop projected to capture $23.4 billion of that total for the full year based on current growth trajectories. The platform's Project Horizon initiative incentivizes marketing agencies to onboard large brands by offering promotional credits, reduced commission rates, and priority access to new features. Affiliate networks on TikTok Shop allow creators to drive sales through commission-based partnerships, with top affiliates earning six-figure monthly incomes from product recommendations embedded in organic-style content. Companies like Portland Leather Goods have marshaled hundreds of loyal fans into affiliate channels, turning customer advocacy into a scalable sales force. The native checkout model removes the need for customers to leave the app, collapsing the traditional funnel from product discovery to purchase completion into a single, seamless experience. Over 82% of consumers now report using social media for product discovery at some stage of their purchasing journey. TikTok Shop's recommendation algorithm surfaces products based on viewing behavior, engagement patterns, and purchase history, creating a personalized shopping feed that differs fundamentally from traditional search-based e-commerce. The shift toward social-first shopping is fundamentally reshaping how brands allocate marketing budgets and design go-to-market strategies. Over 60% of product discovery now occurs on platforms like TikTok, Instagram, and YouTube rather than through traditional search engines or brand websites. Gen Z consumers lean heavily toward TikTok and YouTube for shopping inspiration, while millennials continue to prefer Facebook and Instagram, creating distinct demographic channels that brands must address simultaneously. Engagement metrics like shares, saves, and comments carry more algorithmic weight than raw view counts, rewarding authentic, educational, and entertaining content over polished advertising. Brands are prioritizing short-form video content that provides genuine value, product tutorials, behind-the-scenes manufacturing, styling advice over traditional promotional messaging. Corporate marketing processes, however, make it more difficult for large brands to post with the frequency and spontaneity that founder-led startups achieve, creating an authenticity gap that algorithms can penalize. The platform is clearly maturing from a flash sale novelty into a legitimate retail channel, with brands investing in dedicated TikTok commerce teams, content studios, and performance analytics. Legal subtopics. 3.1 TikTok's U.S. legal status and potential ban. TikTok's U.S. operations remain under intense legal scrutiny through the Committee on Foreign Investment in the United States (CFIUS) review process, which has the authority to block or force divestiture of foreign acquisitions that threaten national security. Congressional legislation requiring ByteDance to divest TikTok's U.S. operations established specific deadlines that have been subject to extensions in executive action, creating ongoing uncertainty for the platform's commercial operations. ByteDance's ownership structure, including Chinese investors subject to PRC data security laws, forms the core of the national security argument, with concerns centered on potential CCP access to American user data and algorithmic content manipulation. First Amendment challenges to any TikTok ban argue that government restriction of a communications platform used by over 170 million Americans constitutes an unconstitutional prior restraint on speech. Federal courts have issued conflicting rulings on the constitutionality of platform-specific bans, with some finding sufficient national security justification and others requiring more targeted remedies. The legal uncertainty directly impacts TikTok Shop's commercial viability, as brands must weigh investment in a platform that could face operational restrictions or forced ownership changes. Any divestiture would require separating TikTok Shop's U.S. e-commerce infrastructure, including payment processing, seller agreements, and consumer data, from ByteDance's global operations, a technically and legally complex undertaking. 3.2 Social Commerce Consumer Protection. The FTC's endorsement guidelines require influencers and content creators to clearly and conspicuously disclose material connections, including commission payments, free products, and affiliate relationships when promoting products on social commerce platforms. Compliance with the #ad disclosure requirement remains inconsistent on TikTok, where the fast-paced, immersive video format can obscure required disclosures that are displayed only briefly or in small text overlays. The FTC has brought enforcement actions against both individual influencers and brands that fail to ensure adequate disclosure, with penalties including civil fines and mandatory compliance monitoring. Deceptive endorsement liability extends to brands that provide influencers with scripted testimonials or false product claims, even if the brand did not directly post the content. Social commerce platforms face increasing pressure to implement automated disclosure detection systems that flag non-compliant content before it reaches consumers. The blending of organic content and paid promotion in social commerce creates a consumer deception risk that traditional advertising regulation was not designed to address. State consumer protection statutes provide additional enforcement mechanisms, with state attorneys general increasingly pursuing social media advertising violations alongside federal FTC actions. 3.3 TikTok Shop Seller Liability and Product Safety. Product recall responsibilities on TikTok Shop raise complex questions about whether the platform, the seller, or both bear liability when a product causes consumer injury, particularly for products shipped directly from overseas manufacturers. The Consumer Product Safety Commission, CPSC, has increased attention to social commerce platforms, issuing guidance that marketplace facilitators may have independent recall notification obligations separate from those of the original product manufacturer. Counterfeit goods on TikTok Shop, ranging from beauty products with harmful ingredients to electronics with faulty components, create product liability exposure that can result in personal injury claims, class actions, and regulatory enforcement. The legal distinction between TikTok Shop as a passive marketplace versus an active participant in the sales process affects whether the platform qualifies as a seller or distributor under state product liability law. Consumer injury claims arising from products purchased through social commerce face jurisdictional complexities when the seller is located overseas and the platform operates across multiple states. TikTok Shop's product listing requirements and seller verification processes are legally relevant because they determine whether the platform has exercised sufficient due diligence to avoid negligent facilitation claims. The platform's integration of payments, shipping, and returns into a unified experience may strengthen arguments that TikTok Shop functions as a de facto seller rather than a neutral marketplace intermediary. 3.4 TikTok Data Privacy and Children's Online Safety. TikTok's compliance with the Children's Online Privacy Protection Act, COPPA, is under active FTC investigation, with regulators examining whether the platform adequately restricts data collection from users under 13 and whether its age verification mechanisms are effective. State children's privacy laws, including California's Age-Appropriate Design Code Act and similar legislation in other states, impose additional obligations on platforms that are likely to be accessed by children, a standard that TikTok clearly meets given its demographic profile. Age verification requirements for social commerce transactions create tension between privacy, collecting government IDs, and protection, preventing minors from making unauthorized purchases, with no clear regulatory consensus on the optimal approach. TikTok collects extensive behavioral data including viewing patterns, engagement metrics, purchase history, and biometric information from facial features in videos, creating a comprehensive user profile that raises concerns under both COPPA and general privacy statutes. The FTC's 2024 updates to COPPA regulations expanded the definition of personal information to include persistent identifiers used for behavioral advertising, directly impacting how TikTok Shop can target product recommendations to younger users. International data transfers between TikTok's U.S. operations and ByteDance's infrastructure raise additional privacy concerns under both GDPR, for European users, and proposed federal privacy legislation. The convergence of children's safety, data privacy, and commercial activity on a single platform creates a regulatory challenge that existing law addresses incompletely and inconsistently. 3.5 Social Commerce Tax Collection and Marketplace Facilitator Laws. TikTok Shop's obligations as a marketplace facilitator require it to collect and remit sales tax in the 46 states, plus D.C., that impose sales tax, pursuant to marketplace facilitator statutes enacted following the Supreme Court's 2018 South Dakota v. Wayfair decision. Each state's marketplace facilitator law has different thresholds, definitions, and reporting requirements, creating a complex compliance matrix that TikTok must navigate for every transaction processed through its platform. Cross-border digital services taxes imposed by countries including France, the UK, and India add international tax obligations that apply when TikTok Shop facilitates sales to or from those jurisdictions. The determination of whether TikTok Shop qualifies as a marketplace facilitator versus a payment processor or advertising platform affects its tax collection obligations and has been contested by platforms seeking to minimize compliance burdens. State tax audit exposure is significant because errors in tax collection, remittance, or reporting can result in assessments against the platform for uncollected taxes, penalties, and interest. Affiliate-driven sales create additional tax complexity because the affiliate's location, the seller's location, and the buyer's location may all be in different states with different rules. TikTok Shop's rapid growth has outpaced the development of its tax compliance infrastructure, creating risk that state revenue departments will identify systemic collection shortfalls during future audits. 3.6 TikTok Affiliate Marketing and FTC Endorsement Guidelines. The FTC's updated endorsement guidelines, most recently revised in 2024, impose specific requirements on TikTok Shop's affiliate marketing ecosystem, including mandatory disclosure of material connections between creators and the products they promote. Material connections include not only direct commission payments but also free products, discounts, business relationships, and even personal friendships with brand representatives, all of which must be disclosed clearly and conspicuously to consumers. TikTok's affiliate program structure, where creators earn commissions on sales generated through their content, creates a financial incentive to make exaggerated product claims that may constitute deceptive advertising. The FTC has established that disclosures must be in the same medium as the endorsement, meaning TikTok creators must make verbal disclosures in their videos rather than relying solely on text and video descriptions that many viewers never read. Penalties for non-compliance with FTC endorsement guidelines include civil penalties of up to $50,120 per violation, with the potential for significantly larger aggregate fines in cases involving systematic non-disclosure. Brands that participate in TikTok Shop's affiliate program bear co-liability for endorsement guideline violations by their affiliates, creating an obligation to monitor, train, and enforce compliance across potentially thousands of creator partners. The scale and speed of TikTok's affiliate ecosystem, with millions of product recommendations posted daily, makes comprehensive compliance monitoring a significant operational and legal challenge for both the platform and participating brands. 3.7 Live shopping and consumer fraud prevention. Live shopping events on TikTok, which generate significantly higher conversion rates than static content, create unique consumer fraud risks, including flash sale deception, artificial scarcity claims, and manipulated viewer counts that inflate perceived demand. The real-time nature of live commerce means that consumer protection disclosures must be delivered orally and visually during the broadcast, a format that is inherently more difficult to monitor and enforce than static advertising. Fake review manipulation, including coordinated positive comments during live streams and suppression of negative feedback, distorts consumer perceptions and may violate the FTC Act's prohibition on unfair or deceptive practices. Return policy enforcement in live commerce is complicated by the impulse-driven nature of purchases, with some sellers establishing restrictive return policies that may conflict with state consumer protection laws requiring reasonable return accommodations. The FTC has not yet issued specific guidance on live shopping regulation, creating a legal gray area that platforms and sellers must navigate using general principles of consumer protection law. Fraud prevention obligations include verifying seller identities, monitoring for counterfeit goods, and ensuring that live shopping events do not employ bait-and-switch tactics that lure consumers with advertised products and deliver inferior substitutes. TikTok's platform algorithms, which amplify high-engagement content including live shopping events, create a system where fraudulent sellers can reach massive audiences before platform moderation systems identify and remove violating content. 4 E-TSE posts Q1 growth as AI-driven search reshapes the marketplace. E-TSE's Q1 2026 marketplace GMS grew 5.5% year-over-year to $2.5 billion, or 3.6% on a currency-neutral basis, marking a return to modest growth after several quarters of stagnation in the post-pandemic environment. Revenue reached $631.3 million, up 3.1%, with marketplace revenue growing 6.3% and services revenue rising 10.5%, reflecting increased seller adoption of E-TSE's advertising and promotional tools. Net income was $104.7 million, reversing a loss from the year-ago quarter and demonstrating improved cost discipline and revenue quality. The company shifted its marketing spend allocation toward paid search channels with measurable return on investment and brought paid social media management in-house, reducing agency costs. E-TSE entered an agreement to sell Depot to eBay in February 2026, pending regulatory approval, a divestiture that will generate cash while shedding a business unit that had underperformed growth expectations. The company continues to operate E-TSE.com as the global destination for unique, handcrafted, and vintage goods, a positioning that differentiates it from mass-market competitors. Active buyer count stabilized at approximately 92 million, with management focused on increasing purchase frequency rather than expanding the buyer base. E-TSE's 2026 search algorithm represents a fundamental shift in how products are discovered on the platform, now prioritizing buyer engagement metrics, click-through rates, add-to-cart actions, and completed purchase rates alongside listing quality scores and customer experience ratings. Over 70% of E-TSE searches occur on mobile devices, requiring the algorithm to optimize for smaller screens where visual impact and listing relevance are even more critical. AI-assisted query understanding interprets search intent more semantically, meaning a search for "gift for mom who likes gardening" returns results that understand the relationship, occasion, and interest context rather than simply matching keywords. Sellers who optimize their photography, pricing competitiveness, and keyword relevance see measurably faster ranking improvements under the new system. The rise of AI-generated search results across the broader internet, including Google's AI overviews and chatbots shopping features, is reducing reliance on traditional paid clicks and reshaping how consumers discover ETSE products. Studies show that top-ranking page click-through rates can decline sharply when AI overview answers appear above organic results, affecting traffic to marketplace listings. Brands and sellers are increasingly focused on being cited as authoritative sources in AI outputs rather than competing solely for traditional search placement. ETSE's Spring/Summer 2026 trend reports highlight sustained demand for handcrafted, personalized products tied to weddings, graduations, and home refreshes, categories that align with ETSE's core artisan marketplace identity. Integration with Shopify offers ETSE sellers broader reach through multi-channel strategies, with data suggesting merchants who sell on both platforms achieve 30 to 40% revenue gains compared to single-platform sellers. ETSE has deployed targeted reactivation campaigns, sending lapsed buyers $5 coupons to incentivize return purchases, a strategy that has shown positive conversion rates in pilot programs. The platform faces ongoing competitive pressure from mass-produced goods on Amazon Handmade and an influx of manufactured items on TikTok Shop that blur the line between handmade and factory-produced. ETSE's brand message, "Keeping Commerce Human in a World of Algorithm-Driven Retail," resonates with consumers who value authenticity, but the company must continuously enforce quality standards. The depot sale to eBay would remove a key growth asset from ETSE's portfolio but would generate significant cash for reinvestment in the core marketplace platform. ETSE's central challenge remains maintaining artisan authenticity and seller quality while scaling technologically to compete with platforms that offer superior logistics and broader selection. Legal subtopics. 4.1 ETSE depot sale to eBay. The ETSE eBay depot transaction requires antitrust review to assess whether consolidating two major resale fashion marketplaces would substantially reduce competition in the second-hand clothing and accessories market. The FTC may evaluate whether the combined eBay depot entity would control a disproportionate share of online resale, particularly among Gen Z consumers who have driven growth in both platforms. Competitive impact analysis must consider whether alternatives including Poshmark, ThredUp, Mercury, and Facebook Marketplace provide sufficient competitive constraint to prevent anti-competitive behavior post-acquisition. The deal price and structure will be scrutinized by ETSE shareholders, who may argue through derivative suits that the board undervalued Depot or failed to conduct an adequate market check before agreeing to sell. Data migration from ETSE's systems to eBay's infrastructure must comply with user consent requirements under both US and European privacy laws, as Depot users did not consent to eBay processing their personal information when they created their accounts. Employment law implications arise for Depot employees who may face redundancies or relocation requirements following the acquisition, triggering WARN Act notification obligations if the workforce reduction exceeds applicable thresholds. The regulatory approval timeline, expected to extend through mid-2026, creates an interim period during which both companies must operate Depot independently while honoring obligations under the merger agreement. 4.2 AI Search Algorithm Transparency and Seller Fairness. ETSE's AI-driven search algorithm determines which products appear in search results and in what order, a decision that directly impacts individual seller livelihoods and has generated claims of algorithmic bias and discriminatory treatment. The EU Digital Markets Act requires designated gatekeeper platforms to ensure fair and non-discriminatory treatment of business users, including transparent ranking criteria and prohibition of self-preferencing obligations that could extend to ETSE if it meets the DMA's quantitative thresholds. Seller discrimination lawsuits have been filed alleging that ETSE's algorithm systematically favors established sellers with high transaction volumes, creating barriers to entry for new and small-scale artisans. Algorithmic transparency obligations are expanding globally, with regulations requiring platforms to explain the main parameters used in ranking and provide sellers with information about how their listings are prioritized or demoted. The use of AI in search introduces concerns about feedback loops. The algorithm promotes products that perform well, which generates more data that further entrenches those products' positions, potentially locking out equally deserving alternatives. ETSE's responsibility to ensure its AI systems do not discriminate based on protected characteristics including seller race, gender, national origin, or disability status adds a civil rights dimension to algorithmic fairness requirements. Legal challenges to search algorithms face significant hurdles because platforms typically argue that their ranking systems are proprietary trade secrets, creating tension between the need for transparency and the protection of intellectual property. 4.3 ETSE Intellectual Property and Counterfeit Enforcement. ETSE's obligations under the Digital Millennium Copyright Act, DMCA, require the platform to promptly remove listings that infringe copyrights upon receiving valid takedown notices from rights holders, while providing counter-notification procedures for sellers who believe their listings were wrongly removed. Trademark infringement on ETSE is particularly complex because the handmade marketplace includes items that incorporate brand names in descriptive ways such as, case compatible with iPhone 15, that may or may not constitute fair use depending on context. The platform processes thousands of intellectual property reports monthly, and its enforcement accuracy directly affects both seller trust and brand relationships, with false removals potentially constituting tortious interference with seller businesses. Design patent disputes arise when sellers create products that are visually similar to patented designs such as jewelry or furniture, raising questions about whether handmade items independently created without knowledge of the patent constitute infringement. ETSE's repeat infringer policy, required to maintain DMCA safe harbor protection, must balance rigorous enforcement with protection against abuse of the takedown system by competitors filing fraudulent IP claims. International IP enforcement is particularly challenging because many ETSE sellers operate from countries with different intellectual property frameworks, and the platform must navigate jurisdictional complexities in applying IP policies globally. The growing use of AI tools to generate product listings and designs adds a new dimension to IP enforcement, as AI-generated content may inadvertently incorporate protected elements from training data. 4.4 ETSE Seller Employment Classification. The classification of ETSE sellers as independent contractors versus employees or dependent workers is an emerging legal question driven by the platform's increasing control over pricing, shipping, customer service standards, and seller behavior through its marketplace policies. Under the economic realities test used by the Department of Labor, factors such as the degree of control exercised by the platform, the seller's opportunity for profit or loss, and the permanence of the relationship all weigh on classification, and ETSE's algorithm-driven visibility system arguably limits seller independence. California's ABC test, which presumes worker status unless the hiring entity proves the worker is free from control, customarily engaged in the occupation, and operating an independent business, creates particular exposure for platforms that impose significant operational requirements on sellers. The gig economy regulatory movement has primarily focused on rideshare and delivery workers, but legal scholars argue that the same principles apply to marketplace sellers whose economic dependence on a single platform effectively functions as employment. If ETSE sellers were reclassified as employees, the company would face obligations including minimum wage, overtime, benefits, workers' compensation, and payroll tax contributions, a financial impact that would fundamentally alter the marketplace business model. European regulators have advanced platform work directives that specifically address the employment status of platform workers, and while these currently focus on rideshare and delivery, the principles could extend to marketplace sellers. ETSE maintains that its sellers are independent entrepreneurs who set their own hours, design their own products, and choose whether and when to sell, a position that aligns with traditional independent contractor analysis but faces increasing legal challenge. 4.5 ETSE Data Privacy and GDPR Compliance. ETSE processes personal data of approximately 92 million active buyers and millions of sellers globally, creating extensive obligations under the EU General Data Protection Regulation for any user data involving European residents. The EU.s Data Privacy Framework, which replaced the invalidated Privacy Shield, governs ETSE's cross-border data transfers between European operations and US data centers, and any judicial challenge to this framework could disrupt ETSE's data processing operations. Cookie consent requirements under the e-Privacy Directive mandate that ETSE obtain informed, specific consent before placing tracking cookies on EU visitors' devices, a requirement that reduces the platform's ability to collect behavioral data for targeted advertising and search optimization. ETSE's role as both a data controller, for its direct relationships with users, and a data processor, handling data on behalf of sellers, creates dual compliance obligations with distinct requirements for data protection, impact assessments, breach notification, and records of processing activities. The right to erasure under GDPR Article 17 creates operational challenges when buyers request deletion of their data, as purchase histories, reviews, and communications may be needed by sellers for tax, legal, and business purposes. ETSE's use of AI in search and recommendations triggers GDPR Article 22 requirements regarding automated decision-making, potentially requiring the platform to provide meaningful information about the logic involved and allow users to contest automated decisions. Data subject access requests, which ETSE must fulfill within 30 days under GDPR, have become a significant operational burden as privacy-conscious users increasingly exercise their data rights. 4.6 ETSE Consumer Protection and Return Policies. ETSE's marketplace model creates a complex consumer protection landscape because the platform facilitates transactions between independent sellers and buyers but also sets marketplace-wide policies including its purchase protection program that create enforceable consumer expectations. State consumer protection laws vary significantly in their application to marketplace platforms. Some states hold the platform liable for defective or misrepresented products sold through its site, while others limit liability to the individual seller. The EU Consumer Rights Directive grants European buyers a mandatory 14-day withdrawal period for online purchases, a right that applies to ETSE sellers regardless of their individual return policies and that the platform must help enforce. Defective product liability on ETSE raises questions about whether handmade items which may not be subject to the same safety testing and certification as mass-produced goods expose sellers to heightened liability when products cause injury. ETSE's case resolution system, which mediates disputes between buyers and sellers, must comply with applicable state arbitration laws and the Federal Arbitration Act, and its mandatory arbitration clauses have faced challenges under consumer protection statutes in several jurisdictions. The platform's buyer protection program creates a de facto warranty that may expose ETSE to claims beyond those faced by a pure marketplace intermediary, particularly in jurisdictions where consumer protection law imposes liability on entities that process payments and control the transaction experience. ETSE must balance robust buyer protection with fair treatment of sellers, many of whom are individual artisans without the legal resources to defend against unfounded buyer complaints. 4.7 ETSE AI-generated product listings and disclosure requirements. The growing use of AI tools to generate product descriptions, titles, and tags on ETSE raises questions about whether listings created or substantially assisted by artificial intelligence must be disclosed to consumers under existing and proposed transparency requirements. The FTC's deception framework applies when AI-generated content creates false impressions about a product. For example, if AI-generated descriptions exaggerate product qualities or fabricate details about handcrafted production processes that don't reflect reality. ETSE's brand identity as a marketplace for handmade, human-created goods creates particular sensitivity around AI-generated content, as buyers may reasonably expect that product descriptions were written by the artisan who made the item. Authenticity labeling requirements being considered at both federal and state levels would require sellers to disclose when AI tools were used to create any aspect of a product listing, including text, images, and pricing optimization. ETSE's own policies may need to distinguish between acceptable AI assistance, such as grammar correction or translation, and problematic AI generation, such as fabricated product backstories or misleading quality claims. The use of AI image generation to create product photography that doesn't accurately represent the actual item creates additional deception concerns, particularly for handmade goods where visual accuracy is essential to the buyer's purchase decision. International disclosure requirements for AI-generated content, including the EU AI Act's transparency obligations, add another layer of compliance complexity for ETSE sellers who sell across borders. 5 Wayfair returns to active customer growth in Q1. Outpaces home furnishings market. Wayfair reported Q1 2026 revenue of $2.93 billion, up 7.4% year-over-year, meaningfully outperforming a home furnishings market that declined in the low single digits during the same period. Active customers reached 21.4 million, up 300,000 from the prior quarter, marking the first sustained active customer growth in over 2 years. The company posted its best Q1 adjusted EBITDA margin in 5 years at 5.2%, reflecting cost reduction initiatives, improved supplier economics, and higher advertising efficiency. Orders delivered were 9.4 million, up 3.3% year-over-year, with growth driven by both new and repeat customer orders. Average order value rose to $312 from $301 a year earlier, indicating a trade-up trend toward higher quality furniture and home decor. Mobile orders accounted for 64.7% of total deliveries, reinforcing the critical importance of app-based shopping experiences in the home category. Repeat customers placed 79.8% of all orders, demonstrating strong brand loyalty and the effectiveness of Wayfair's retention strategies. Wayfair's competitive edge lies in mid-range furniture with 40 to 70% flash sale discounts and style-based shopping tools that help consumers visualize products in their homes before purchasing. Amazon dominates small home decor items under $50 with prime delivery speed, but Wayfair wins in larger, higher consideration furniture purchases where design expertise and curated selection matter more than delivery time. Wayfair offers free design services through its MyWay program and app-exclusive deals to deepen engagement and drive conversion from browsing to purchasing. The company's Wayfair Rewards loyalty program is being expanded with additional tiers and benefits designed to increase purchase frequency and average order values among the most valuable customer segments. Way Day sales events, held biannually, drive major traffic spikes and serve as both customer acquisition and retention tools, generating significant media coverage and social media engagement. Analysts note that smart shoppers increasingly mix purchases between Wayfair for furniture and Amazon for smaller accessories, creating a category-specific competitive dynamic rather than winner-take-all. International revenue of $319 million grew 6% year-over-year, primarily driven by strength in the UK and German markets. Q2 2026 guidance projects mid-single-digit revenue growth with gross margins of 29.5 to 30.5% and adjusted EBITDA margins of 6 to 7%, suggesting continued improvement in unit economics and profitability. Wayfair plans selective physical store expansion alongside its digital growth strategy, with flagship showroom concepts designed to showcase large furniture items that consumers prefer to see and touch before purchasing online. Exclusive products and enhanced app experiences, including augmented reality room visualization tools, are investment priorities for the second half of 2026. The company's loss from operations narrowed significantly to $11 million from $122 million a year ago, demonstrating progress towards sustainable profitability. Free cash flow was negative $106 million, improving from negative $139 million in the prior year, with management targeting positive free cash flow by Q4. 3/2026. Wayfair is investing in logistics infrastructure and last-mile delivery technology to compete on speed and reliability, areas where the company has historically lagged behind Amazon. The home furnishings recovery is expected to accelerate in the second half of 2026, supported by easing interest rates, increased home sales, and a backlog of deferred home improvement projects. Legal subtopics. 5.1 Wayfair product liability and furniture safety recalls. Wayfair's marketplace model, where the company sells both its own private label furniture and products from thousands of third-party suppliers, creates layered product liability exposure that varies based on Wayfair's role in each transaction. The Consumer Product Safety Commission, CPSC, mandates that companies report potential product defects within 24 hours of discovery, and Wayfair's scale with millions of product listings requires robust systems to monitor safety complaints and identify recall-worthy issues. Product recall procedures for furniture involve coordination between manufacturers, the CPSC, and the retailer, with legal obligations extending to consumer notification, remedy provision, repair, replacement, or refund, and reporting of injuries. Third-party seller liability for defective items sold through Wayfair creates indemnification disputes, particularly when overseas manufacturers lack U.S. insurance coverage or are outside the jurisdiction of American courts. Children's furniture and nursery products face heightened safety standards under PSEA requirements, including mandatory third-party testing and certification, and Wayfair bears compliance responsibility for products sold under its private label brands. Tip-over hazards for dressers, bookshelves, and other tall furniture have generated significant litigation industry-wide, with the Sturdy Act proposing mandatory stability standards that would require Wayfair to verify compliance across its entire catalog. Product liability lawsuits against Wayfair typically allege negligent selection, distribution, or failure to warn, and the company's exposure depends on whether courts classify it as a retailer, distributor, or marketplace facilitator under the applicable state's product liability statute. 5.2 Wayfair sales tax and South Dakota v. Wayfair ongoing impact. The Supreme Court's landmark 2018 decision in South Dakota v. Wayfair Incorporated eliminated the physical presence requirement for state sales tax collection, enabling states to require remote sellers to collect and remit sales tax based on economic nexus, and the case's ongoing impact continues to reshape e-commerce tax compliance. Wayfair now collects sales tax in all states that impose it, but the compliance challenge lies in the variation across approximately 13,000 tax jurisdictions with different rates, exemptions, product classifications, and filing frequencies. The economic nexus thresholds established post-Wayfair vary by state. Most use $100,000 in sales or 200 transactions, but some states have adopted different standards, creating an uneven compliance landscape. State audit exposure for Wayfair is significant because retroactive assessments for alleged undercollection can result in penalties and interest that substantially exceed the underlying tax liability. Local option taxes, special taxing districts, and product-specific tax exemptions, such as lower rates for essential household goods in some jurisdictions, create additional compliance complexity. The Wayfair decision's impact extends beyond direct tax collection to marketplace facilitator laws, which require platforms like Wayfair to collect tax on behalf of third-party sellers, shifting the compliance burden from individual sellers to the platform. Ongoing legislative proposals at the federal level seek to standardize state sales tax requirements for remote sellers, but progress has been slow, leaving companies like Wayfair navigating a fragmented state-by-state compliance framework. 5.3 Wayfair customer data privacy and security. Wayfair collects extensive customer data including browsing behavior, purchase history, home addresses, payment information, room dimensions, and style preferences, creating a comprehensive profile that triggers obligations under state privacy laws. The California Consumer Privacy Act, CCPA, and its successor CPRA grant Wayfair's California customers specific rights, including the right to know what data is collected, the right to delete personal information, the right to opt out of sales or sharing, and the right to limit use of sensitive personal information. Data breach notification requirements vary by state but generally require notification within 30 to 60 days of discovering a breach, with specific content requirements and regulatory reporting obligations that Wayfair must satisfy in every state where affected customers reside. Wayfair's augmented reality features, which may capture room images and dimensions through smartphone cameras, raise additional privacy concerns about the collection and storage of visual data depicting the interior of customers' homes. The company's data security obligations extend to its third-party suppliers and logistics partners, creating a chain of liability for breaches that originate in systems operated by vendors with access to Wayfair customer data. Consumer data rights requests including deletion requests, access requests, and opt-out requests must be processed within statutory timeframes, requiring investment in automated systems that can identify and act on all instances of a customer's data across Wayfair's systems. The proliferation of state privacy laws with Virginia, Colorado, Connecticut, Utah, Texas, Oregon, and Montana all enacting comprehensive privacy legislation creates a patchwork compliance environment that may only be resolved by federal preemptive legislation. 5.4 Wayfair Delivery and Logistics Worker Classification. Wayfair's last-mile delivery operations rely on a network of independent delivery partners and contract carriers whose employment status has been challenged in lawsuits alleging that Wayfair exercises sufficient control over delivery processes to establish an employment relationship. Worker classification lawsuits focus on factors including Wayfair's control over delivery windows, customer communication requirements, uniform and vehicle branding standards, and use of GPS tracking and performance metrics that mirror employer-employee supervision. Wage and hour claims from delivery workers allege that when total compensation including wait time, loading, and drive time is calculated on an hourly basis, effective pay falls below minimum wage in some jurisdictions, violating the Fair Labor Standards Act. California's AB5 codified the strict ABC test for worker classification, making it particularly difficult for companies using contract delivery workers to maintain independent contractor status unless the workers are performing work outside the usual course of the company's business. The economic implications of reclassification are substantial. Wayfair would need to provide benefits, workers' compensation insurance, unemployment insurance, and payroll tax contributions for reclassified delivery workers. Joint employer liability creates additional exposure when Wayfair contracts with staffing agencies or delivery companies that misclassify their own workers, as courts may find that Wayfair's control over working conditions makes it a joint employer responsible for labor law violations. The Department of Labor's 2024 final rule on independent contractor classification under the FLSA uses a multi-factor, economic reality test that some legal analysts argue makes it more difficult for companies like Wayfair to defend the independent contractor status of dedicated delivery workers. 5.5 Wayfair Advertising Accuracy and Price Comparison Claims. Wayfair's use of compare-it pricing, which displays a reference price alongside Wayfair's discounted price, has faced legal challenges alleging that the reference prices are inflated, fictional, or do not reflect prices at which the products are actually sold by competitors. The FTC's guidelines on deceptive pricing require that compare-it or was prices reflect genuine former selling prices or actual competitor prices, not manufacturers' suggested retail prices, MSRPs, that no retailer actually charges. Class action lawsuits filed in multiple states allege that Wayfair's pricing practices create a false sense of urgency and savings, violating state consumer protection statutes that prohibit deceptive advertising. Reference price litigation has resulted in significant settlements in the retail industry, and courts have generally held that retailers bear the burden of substantiating the accuracy of their comparison prices. Wayfair's flash sale model, which features prominently discounted prices available for limited time periods, must comply with FTC requirements that sale prices represent genuine temporary reductions from regular prices actually charged. The company's pricing algorithms, which dynamically adjust prices based on demand, competition, and inventory levels, create additional complexity because regular prices may fluctuate frequently, making it difficult to establish a consistent baseline for comparison pricing claims. State consumer protection enforcement varies, with California, New York, and Illinois particularly active in pursuing deceptive pricing cases against online retailers. 5.6 Wayfair Physical Store Expansion and Zoning/Retail Regulations. Wayfair's plan for selective physical store expansion introduces legal considerations around commercial real estate, including lease negotiations, tenant improvement obligations, and the allocation of risk between landlord and tenant for issues such as environmental contamination, structural defects, and insurance. Zoning regulations determine where Wayfair can locate showrooms, with retail classifications, parking requirements, signage restrictions, and operating hour limitations varying by municipality and creating a unique compliance profile for each location. The Americans with Disabilities Act, ADA, imposes specific requirements on retail establishments, including wheelchair accessibility, accessible display configurations, and service animal accommodations, with non-compliance exposing Wayfair to private lawsuits and Department of Justice enforcement actions. Local retail licensing requirements vary significantly by jurisdiction and may include business operating permits, sales tax registration, fire safety inspections, health department approvals, for locations with food service, and employment law compliance certifications. Building codes and fire safety regulations affect store design decisions, including occupancy limits, emergency exit configurations, and sprinkler system requirements, all of which must be satisfied before opening to the public. Historic preservation requirements in certain urban locations may restrict exterior modifications, signage, and architectural changes, limiting Wayfair's ability to implement standardized brand aesthetics across locations. The transition from pure-play e-commerce to physical retail also introduces workers' compensation obligations, premises liability exposure for customer injuries, and retail-specific employment law requirements that Wayfair's operations have not previously needed to address. 5.7 Wayfair International Operations and Cross-Border Consumer Protection. Wayfair's international operations primarily in the UK, Germany, and Canada are subject to the EU Consumer Rights Directive, as retained in UK law post-Brexit, and the Canadian Consumer Protection Act, which grant consumers stronger rights than typical US consumer protection statutes. The mandatory 14-day withdrawal period under EU/UK law allows consumers to return most online purchases for any reason without penalty, an obligation that Wayfair must honor regardless of its standard return policy, and which applies to custom or made-to-order furniture in limited circumstances. International return policy mandates create significant logistics costs for large furniture items, including collection from the consumer's home, return shipping, and processing of refunds within statutory timeframes. GDPR compliance for European customers requires Wayfair to maintain a lawful basis for processing personal data, typically consent or legitimate interest, and to provide European data protection authorities with cooperation and access upon request. Cross-border warranty obligations may differ from U.S. standards, with EU law generally requiring a minimum 2-year guarantee on consumer goods, exceeding the 1-year warranties common in the U.S. market. Currency fluctuation risk in international transactions creates customer disputes when prices change between order placement and delivery, particularly for large orders with extended fulfillment timelines. Wayfair's advertising and marketing in international markets must comply with local standards, which in some jurisdictions prohibit or restrict certain marketing techniques such as countdown timers, artificial urgency, and reference pricing that are common in U.S. e-commerce. 6. Shopify pursues nationwide money transmitter licenses in fintech push. Shopify is seeking regulatory approvals across the United States to act as a money transmitter and provider of prepaid access, a strategic move that would fundamentally transform the company from a SaaS e-commerce platform into a full-stack commerce and financial services provider. The company has already obtained money transmitter licenses in 18 states and Puerto Rico, with remaining applications under review in states including New York, California, and Texas jurisdictions with some of the nation's strictest financial services regulations. New York's BIT license and money transmitter requirements, administered by the Department of Financial Services, are notoriously rigorous, requiring extensive documentation of compliance programs, capital reserves, and consumer protection measures. Shopify commands more than 14% of U.S. e-commerce market share, making it the second largest e-commerce platform by market share behind only Amazon. The licensing push would give Shopify greater control over how money moves on its platform, enabling direct merchant deposit holding, faster settlement, and reduced reliance on third-party payment processors. This could generate substantially more revenue from the hundreds of billions of dollars in annual gross merchandise volume processed through Shopify stores. Shopify Capital's gross loan receivables hit $1.6 billion at year-end 2025, up 43% year-over-year, demonstrating strong merchant demand for Shopify-originated financing. With money transmitter licenses, Shopify could hold merchant deposits and expand lending opportunities using that deposit liquidity, creating a banking-like capability without requiring a full bank charter. This positions Shopify decisively beyond its traditional SaaS e-commerce platform role into direct financial services, competing with established players like PayPal, Square, and Stripe in the merchant financial services market. The company could reduce reliance on partner banks such as Celtic Bank and Evolve Bank, improving the economics of financial products by retaining more of the spread between deposit costs and lending yields. Competitors are not standing still. PayPal reported $1.8 billion in merchant loans, up 23% YoY, and Square has announced plans to expand loan access to 50% more merchants in 2026. SMBs are increasingly comfortable with fintech lending alternatives that offer faster approval, automated repayment through sales deductions, and less documentation than traditional bank loans. Shopify's Q4 2025 revenue was $3.67 billion, providing substantial capital to fund the regulatory expansion and technology investment required for financial services compliance. Analysts maintain a consensus buy rating on Shopify with 40 buy ratings versus 20 holds, reflecting confidence in the fintech strategy's long-term revenue potential. Shopify's latest platform updates include AI-powered tools for product description generation, automated customer segmentation, expanded checkout customization features, and analytics dashboards with data-driven business insights. The company added inventory tracking capabilities at non-selling locations, such as warehouses and showrooms, and multiple product discount capabilities that allow merchants to create complex promotional structures. Shopify Collective now lets U.S. retailers set custom retail prices for supplier products, enabling marketplace-style arrangements without the complexity of building a full marketplace infrastructure. The Recharge.Scio merger creates a unified subscription commerce platform processing over $20 billion in GMV, strengthening the ecosystem of apps and services built on Shopify's platform. Shopify's point-of-sale system received mid-session cash count capabilities, improving retail operations for merchants who operate both online and physical stores. The company is enabling merchants to set and track analytics goals with visual gauges, providing real-time performance monitoring previously available only through third-party analytics tools. These platform updates collectively strengthen Shopify's position as the dominant independent e-commerce platform for small and mid-market merchants. Legal subtopics. 6.1 Shopify Money Transmitter Licensing and State Regulatory Compliance. Money transmitter licensing in the United States requires compliance with a patchwork of state-by-state regulations, as there is no single federal license that authorizes money transmission activity across all jurisdictions. Each state imposes its own application requirements, including minimum net worth or surety bond requirements, background checks on officers and directors, audited financial statements, and detailed compliance program documentation. Shopify must register with the Financial Crimes Enforcement Network, FinCEN, as a money services business, MSB, triggering Bank Secrecy Act, BSA, obligations including anti-money laundering, AML, programs, suspicious activity reporting, SARS, and currency transaction reporting, CTRS. State examinations occur on regular cycles, typically every 12 to 24 months, and require Shopify to demonstrate ongoing compliance with all licensing conditions, consumer protection requirements, and financial safety and soundness standards. Consumer protection obligations under state money transmission laws include providing clear disclosures about fees, exchange rates, and error resolution procedures, as well as maintaining permissible investments for funds held in transit. The nationwide multi-state licensing system, NMLS, streamlines certain aspects of multi-state licensing but does not eliminate the need to satisfy each state's unique requirements, many of which involve in-person interviews and state-specific compliance documentation. Failure to obtain required licenses before conducting money transmission activity can result in criminal penalties under both state and federal law, making Shopify's phased licensing approach a regulatory necessity rather than a strategic choice. 6.2 Shopify Capital Lending and Consumer Financial Protection. Shopify Capital's merchant lending products, including merchant cash advances and term loans, raise questions about whether the Truth in Lending Act, TILA, applies, as TILA's disclosure requirements traditionally apply to consumer credit but may extend to business lending under certain state laws. State usury laws cap the interest rates that lenders can charge, and Shopify must ensure that its effective APR, including origination fees, factor rates, and any other charges, does not exceed applicable state limits in each jurisdiction where it lends. Merchant lending disclosure requirements are evolving, with states like California, SB 1235, New York, Virginia, and Utah enacting mandatory commercial financing disclosure laws that require lenders to provide standardized APR disclosures, total cost of financing, and comparison shopping information. The Consumer Financial Protection Bureau, CFPB, has signaled interest in extending oversight to fintech lending platforms, and any rulemaking that classifies Shopify Capital's products as consumer-like credit could dramatically increase compliance obligations. Shopify's automated underwriting, which uses merchant sales data, purchase patterns, and platform behavior to make lending decisions, must comply with fair lending laws that prohibit discrimination based on race, gender, national origin, and other protected characteristics, even when disparate impact is unintentional. The merchant cash advance structure, where repayment is deducted as a percentage of daily sales, has faced legal challenges over whether it constitutes a loan subject to lending regulation or a purchase of future receivables exempt from usury limits. Shopify's growing loan portfolio creates credit risk that must be managed through adequate loss reserves, and regulatory expectations for loss provisioning are becoming more stringent as fintech lenders' portfolios mature through economic cycles. 6.3 Shopify Payments and PCI DSS Compliance. Shopify Payments processes billions of dollars in card transactions annually, creating obligations under the Payment Card Industry Data Security Standard, PCI DSS, to maintain comprehensive security controls including encryption of cardholder data, regular vulnerability scanning, and access control restrictions. PCI DSS compliance is validated through annual assessments conducted by a qualified security assessor, QSA, and as a Level 1 service provider, Shopify must undergo the most rigorous assessment methodology and maintain a report on compliance, ROC. Liability for merchant breaches that occur on Shopify-hosted stores raises questions about the allocation of responsibility between the platform, which provides the infrastructure, and the merchant, which may install third-party apps or scripts that introduce vulnerabilities. The payment card brands, Visa, MasterCard, etc., can impose fines on Shopify's acquiring bank for PCI DSS non-compliance, which are then passed through to Shopify, creating significant financial exposure for security failures. Chargeback dispute resolution processes must comply with both card brand rules and the Electronic Fund Transfer Act, with Shopify acting as an intermediary between merchants and issuing banks in contested transactions. Shopify's expansion into direct payment processing through money transmitter licensing may change its PCI DSS classification and increase the scope of its compliance obligations, particularly around direct handling of funds rather than pass-through processing. The introduction of new payment methods including buy now pay later integrations, cryptocurrency acceptance, and mobile wallet payments creates additional compliance complexity as each payment method has its own regulatory and security framework. 6.4 Shopify Platform Liability for Merchant Fraud. Shopify's role as a platform that enables merchants to create online stores raises questions about the extent of the company's liability when merchants use Shopify-powered stores to perpetrate fraud, sell counterfeit goods, or deceive consumers. Section 230 of the Communications Decency Act provides some protection for platforms that host third-party content, but this protection has limits, particularly when the platform provides the tools, payment processing, and infrastructure that facilitate fraudulent activity. The FTC has brought enforcement actions against platforms that fail to take reasonable steps to prevent merchant fraud, establishing that willful blindness to fraudulent activity on one's platform can constitute an unfair practice. Shopify processes complaints about fraudulent merchants through its acceptable use policy, but the speed and effectiveness of the takedown process affects both consumer harm and the company's legal exposure. Consumer lawsuits against Shopify for merchant fraud typically allege that the platform negligently failed to screen, monitor, or remove merchants with obvious fraud indicators, and success depends on whether the court applies a reasonable care standard or a broader strict liability framework. The company's marketing of Shopify as a trusted, secure platform creates consumer expectations about merchant quality that may form the basis of negligent misrepresentation claims when those expectations are not met. International fraud cases create jurisdictional challenges, as consumers in one country may be defrauded by merchants in another country using a platform headquartered in a third country, and determining which nation's laws apply requires complex conflict of laws analysis. 6.5 Shopify and Sales Tax Collection. Shopify's marketplace facilitator obligations require the company to collect and remit sales tax on behalf of merchants selling through Shopify-powered channels that qualify as marketplaces, including Shopify's Handshake wholesale marketplace and certain point-of-sale configurations. Nexus determination for Shopify merchants is complex because Shopify's infrastructure, including servers, fulfillment partners, and payment processing locations, may create physical or economic nexus in states where the individual merchant has no independent presence. State audit exposure extends to both Shopify, as marketplace facilitator, and individual merchants, for sales outside the marketplace facilitator framework, creating dual compliance obligations that must be carefully coordinated. Shopify's built-in tax calculation tools use third-party tax engines to determine rates, but merchants remain ultimately responsible for verifying the accuracy of tax calculations and ensuring compliance with state-specific rules on product taxability and exemptions. The distinction between Shopify as a platform provider and Shopify as a marketplace facilitator creates ambiguity about which sales trigger Shopify's collection obligations versus those where the merchant bears independent responsibility. Cross-border sales through Shopify stores raise questions about value-added tax, VAT, collection and remittance, particularly under the EU's One-Stop Shop (OSS) system, which simplifies but does not eliminate VAT compliance for cross-border e-commerce. Shopify's tax compliance infrastructure must accommodate frequent changes in state tax rates, product classifications, and filing deadlines, requiring ongoing investment in technology and regulatory monitoring that smaller merchants could not independently sustain. 6.6 Shopify International Data Transfers and Privacy. Shopify's global merchant base processes personal data of customers worldwide, creating cross-border data transfer obligations under the EU.S Data Privacy Framework, the UK extension to the DPF, and other bilateral data transfer mechanisms. As a data processor acting on behalf of its merchants, who are data controllers, Shopify must maintain data processing agreements, DPAs, that comply with GDPR Article 28 requirements, including provisions on sub-processor engagement, data breach notification, and audit rights. Cross-border merchant data handling raises complexities when a European customer purchases from a US merchant through a Shopify store hosted on Canadian infrastructure, requiring analysis of which jurisdiction's privacy law applies to each data processing activity. GDPR processor obligations require Shopify to process personal data only on documented instructions from the controller, merchant, implement appropriate technical and organizational security measures, and assist merchants in fulfilling their own GDPR obligations, including data subject access requests. Supplementary measures, such as encryption in transit and at rest, pseudonymization, and access controls, are required under the Schrems II framework when transferring data to jurisdictions that do not provide an adequate level of data protection. Shopify's app ecosystem creates additional data transfer concerns because third-party apps installed by merchants may access customer data and transfer it to servers in various jurisdictions, creating a chain of data processing that Shopify must help merchants understand and manage. The potential invalidation of the EU.S data privacy framework following the pattern of Safe Harbor and Privacy Shield invalidations represents an ongoing legal risk that could disrupt Shopify's cross-border data processing operations and require migration to alternative transfer mechanisms. 6.7 Shopify Subscription Commerce and Auto-Renewal Laws. Shopify's subscription commerce ecosystem, powered by apps like Recharge, Bold Subscriptions, and the recently merged Recharge.io platform, must comply with auto-renewal laws that vary significantly across states, creating compliance obligations for both Shopify and its merchants. California's Automatic Renewal Law, ARL, requires clear and conspicuous disclosure of auto-renewal terms before the consumer subscribes, affirmative consent separate from other terms, an acknowledgement that includes cancellation information, and an easy online cancellation mechanism. The FTC's updated negative option rule, finalized in 2024, establishes federal baseline requirements for subscription businesses, including simple cancellation processes, click to cancel, prohibition of dark patterns that make cancellation difficult, and requirements to obtain express informed consent before charging. Merchants operating Shopify subscription stores bear primary compliance responsibility, but Shopify's role in providing the platform infrastructure including checkout flows and payment processing may expose the company to joint liability if its tools facilitate non-compliant subscription practices. Consumer cancellation rights are particularly important in subscription e-commerce because recurring charges create ongoing harm if consumers cannot easily stop payments, and state attorneys general have brought enforcement actions against subscription businesses with total damages in the hundreds of millions of dollars. The Recharge-Skyo merger consolidates subscription commerce infrastructure serving over $20 billion in GMV, creating a dominant platform whose compliance practices will affect millions of consumer subscription relationships. International auto-renewal regulations including the EU Consumer Rights Directive's requirements for pre-renewal notification and easy termination add complexity for Shopify merchants selling subscriptions to customers in multiple jurisdictions. 7. Agentic AI commerce emerges as the next frontier in online shopping. Agentic commerce, where AI systems autonomously discover, evaluate, negotiate, and purchase products on behalf of consumers, is rapidly emerging as a new competitive arena that could fundamentally restructure how online shopping works. Accenture invested in DaVinci Commerce in March 2026 to advance agentic AI-led shopping capabilities, signaling that major consultancies view autonomous commerce as an imminent transformation rather than a distant possibility. McKinsey published a 6-level, agentic commerce automation curve, showing how decision delegation shifts at each level, from basic AI-assisted product browsing to fully autonomous multi-agent marketplaces where AI systems transact with other AI systems. The Linux Foundation established the Agentic AI Foundation with partners including Anthropic, Google, Microsoft, OpenAI, and others, creating governance infrastructure for the protocols that will underpin machine-to-machine commerce. Open-source protocols like MCP, Model Context Protocol, A2A, Agent-to-Agent, AP2, ACP, and UCP enable AI agents to read structured data, negotiate terms, and complete transactions through standardized interfaces. Netcore's Agentic Commerce Shift Report 2026 identifies 6 execution shifts reshaping e-commerce growth, emphasizing that brands must redesign their digital presence for AI interpretation rather than solely for human browsing. AI agents can now anticipate consumer needs based on past behavior, compare prices across hundreds of retailers simultaneously, evaluate product reviews for authenticity, and complete purchases including payment authorization with minimal user input. The 6-level automation curve described by McKinsey ranges from basic AI-assisted browsing, Level 1, through progressively more autonomous capabilities to fully autonomous multi-agent marketplaces, Level 6, where specialized agents negotiate with each other on behalf of consumers and retailers. At higher levels of the curve, specialized agents optimize distinct aspects of the purchase journey. Pricing agents negotiate discounts, logistics agents select optimal shipping methods, payment agents choose the most advantageous payment method, and loyalty agents maximize rewards point utilization. Intent is brokered through reputation signals. AI agents evaluate seller trustworthiness, product quality, and fulfillment reliability using structured data exposed through machine-readable APIs and protocols. Netcore's report finds that brands which fixed execution fundamentals, site speed, structured data, inventory accuracy outperformed those that simply spent more on marketing tools and AI capabilities. Discovery is being redefined from a top-of-funnel marketing activity to a direct sales function, as AI agents bypass traditional advertising channels and go directly to product data to make purchasing decisions. High-performing teams ensure that intent signals translate into action through intelligent follow-up systems that re-engage consumers and their AI agents when purchase intent is detected but not completed. Generative search and zero-click results are central to how AI agents discover and evaluate products, making structured product data and machine-readable policies essential for retailers who want to influence agent recommendations. The implications for retailers are profound and wide-ranging. Brands must be designed not only for human shoppers but for how AI systems interpret, evaluate, and recommend products to consumers. Retailers that expose their pricing policies, return guarantees, loyalty program logic, and product specifications in machine-readable formats will influence how AI ecosystems route consumer demand, gaining preferential treatment in agent recommendations. Those that don't risk becoming interchangeable suppliers competing solely on price, as AI agents default to the lowest cost option when they cannot differentiate based on quality, service, or brand value. The automation curve does not unfold evenly across product categories or consumer segments. Convenience-driven replenishment purchases, household goods, groceries, office supplies, accelerate toward full automation, while high-consideration purchases, furniture, electronics, luxury goods, retain substantially more human involvement and emotional decision-making. Ace Hardware debuted HeyArma, its AI assistant designed for in-store product guidance and project planning, demonstrating that agentic AI is extending beyond online commerce into physical retail environments. The tension between AI optimization and brand storytelling creates strategic challenges. AI agents may deprioritize intangible brand values that influence human purchasing decisions, potentially commoditizing categories that have historically commanded brand premiums. The convergence of AI, commerce, and automation represents one of the biggest inflection points in retail history, comparable to the original transition from physical to online shopping. Legal subtopics. 7.1 AI Agent Liability for Autonomous Purchases. When an AI agent autonomously completes a purchase on behalf of a consumer, fundamental questions of contract law arise, specifically, whether a binding contract has been formed and who bears legal responsibility if the purchase is unauthorized, inappropriate, or results in harm. Traditional contract formation requires mutual assent between parties with legal capacity, but AI agents which are neither natural persons nor legal entities challenge the established framework for determining whether consent was genuinely given. Consumer consent frameworks for AI-mediated purchases must define the scope of authority delegated to the AI agent, including spending limits, product categories, and whether the agent can override consumer preferences when it identifies a better option. Product liability allocation becomes complex when an AI agent selects a product that causes injury. Potential defendants include the consumer who deployed the agent, the AI developer who built it, the platform that facilitated the transaction, and the product manufacturer. The Uniform Commercial Code's provisions on acceptance and rejection of goods may need reinterpretation when a human consumer receives products they did not personally select or approve. Return and refund rights for AI-mediated purchases are unclear. If a consumer sets up an AI agent to make autonomous purchases, do they retain the same return rights as if they had made the purchase manually? Legal scholars are debating whether new statutory frameworks specifically addressing AI agent authority and liability are needed, or whether existing agency law principles can be adapted to govern the relationship between consumers, their AI agents, and the merchants those agents transact with. 7.2 Agentic Commerce and Antitrust. AI agents that route consumer demand to specific retailers based on algorithmic evaluation create new antitrust concerns, particularly if the agent's recommendation criteria systematically favor certain sellers in ways that reduce competition. Algorithmic collusion, where AI pricing agents independently arrive at super-competitive pricing by observing and responding to each other's pricing signals, represents a novel antitrust theory that existing law addresses imperfectly. The FTC has signaled scrutiny of AI-mediated market concentration, recognizing that if a small number of AI shopping agents control a significant share of consumer purchases, those agents' decision-making criteria effectively become market gatekeepers. Vertical integration concerns arise when companies that develop AI shopping agents also operate retail platforms, creating incentives to design agents that prefer their own products or partners, a digital equivalent of self-preferencing that the EU Digital Markets Act explicitly prohibits. The market for AI shopping agents itself may consolidate around a few dominant providers, creating an oligopoly layer between consumers and retailers that extracts economic rent from both sides of the transaction. Price signaling through machine-readable pricing data could enable faster and more effective tacit coordination than was possible when humans set and monitored prices, potentially violating Section 1 of the Sherman Act even without explicit agreement between competitors. Regulators face the challenge of adapting century-old antitrust frameworks to address algorithmic market dynamics that operate at machine speed and scale, far exceeding the pace at which human regulators can investigate and enforce. 7.3 AI Transparency and Consumer Disclosure. Requirements to disclose when AI is making purchasing decisions on a consumer's behalf are emerging under both existing consumer protection frameworks and new AI-specific regulations, including the EU AI Act's transparency obligations for AI systems that interact with consumers. The EU AI Act classifies AI systems by risk level, and AI shopping agents that make purchasing decisions may qualify as high risk or at minimum require transparency disclosures that inform consumers when they are interacting with an AI rather than a human recommendation engine. FTC guidance on AI-driven recommendations has established that undisclosed AI involvement in purchase decisions may constitute a deceptive practice, particularly when consumers reasonably believe they are receiving human-curated recommendations. Consumer surveys indicate that a significant majority of shoppers want to know when AI is influencing their purchasing experience, and failure to disclose AI involvement may undermine consumer trust even when the AI provides objectively better recommendations. The challenge of AI transparency extends to explaining why the AI agent made a particular recommendation, a requirement that conflicts with the black box nature of many AI systems whose reasoning processes cannot be easily articulated in human understandable terms. Retailers may be required to provide consumers with opt-out mechanisms that allow them to bypass AI recommendations and browse products through traditional human-oriented interfaces. The tension between personalization benefits, which AI delivers effectively, and transparency obligations, which may reduce personalization effectiveness, represents an ongoing policy challenge that regulators are addressing through iterative guidance rather than comprehensive legislation. 7.4 AI Agent Data Collection and Privacy. AI shopping agents collect extensive personal data about consumer preferences, purchasing patterns, financial capacity, household composition, and daily routines, creating comprehensive behavioral profiles that trigger obligations under CCPA, GDPR, and other privacy frameworks. The data collected by AI agents often exceeds what consumers would voluntarily provide to a human shopping assistant, as agents can infer sensitive information such as health conditions from supplement purchases or financial stress from discount-seeking behavior from seemingly innocuous transaction patterns. Consent requirements for AI-mediated transactions must address not only the data collected at the point of purchase but also the ongoing behavioral monitoring that enables AI agents to anticipate consumer needs and make proactive purchasing recommendations. GDPR's data minimization principle requires that AI agents collect only the data necessary for their stated purpose, but the effectiveness of AI shopping systems generally improves with more data, creating tension between privacy obligations and service quality. The right to explanation under GDPR and proposed US AI legislation may require AI agent developers to disclose what data factors influenced specific purchasing recommendations, a requirement that involves significant technical complexity. Data sharing between AI agents and retailers raises questions about whether the consumer's data rights follow the data through these intermediary transactions, or whether each party in the chain has independent obligations. AI agent developers must implement privacy by design principles, including data retention limits, purpose limitations, and security safeguards, while competing with rivals whose data practices may be less restrictive, creating a potential race to the bottom that only regulatory enforcement can prevent. 7.5 AI-generated product content and intellectual property. AI systems that generate product descriptions, marketing copy, and comparison content for e-commerce platforms raise unresolved copyright questions about whether AI-generated text receives copyright protection and who owns the rights to AI-created commercial content. The U.S. Copyright Office has established that works created entirely by AI without human authorship are not copyrightable, but works where humans provide creative direction and make meaningful creative choices may qualify for protection, a distinction that is difficult to apply consistently in the e-commerce context. Trademark infringement by AI agents can occur when agents use brand names, logos, or slogans in product comparisons or recommendations without authorization, particularly when the AI creates content that implies brand endorsement or affiliation. Fair use considerations apply when AI agents aggregate and summarize product reviews, specifications, and pricing data from multiple sources, but the boundaries of fair use in AI-generated commercial content remain legally untested. AI training data may include copyrighted product descriptions, photographs, and marketing materials, creating potential claims by rights holders that the AI system's outputs constitute derivative works that infringe their copyrights. Product description generation by AI systems that were trained on competitors' content raises additional concerns about trade secret misappropriation if the AI inadvertently reproduces proprietary product formulations, specifications, or business strategies. The rapid evolution of AI content generation capabilities is outpacing the development of intellectual property frameworks, creating a period of legal uncertainty that will likely be resolved through litigation, regulatory guidance, and eventually legislative action. 7.6 Agentic Commerce and Consumer Fraud Prevention. Deepfake technology applied to AI shopping environments creates fraud risks including fake product demonstrations, fabricated customer testimonials, and impersonation of legitimate brand representatives in AI-mediated sales interactions. Fraudulent AI agent services may present themselves as helpful shopping assistants while actually collecting consumer financial data, making unauthorized purchases, or steering consumers toward overpriced products in exchange for undisclosed commissions from retailers. The FTC has authority to bring enforcement actions against deceptive AI tools under Section 5 of the FTC Act, and early enforcement signals suggest the Commission will prioritize cases where AI fraud causes significant consumer financial harm. AI-powered phishing attacks that impersonate legitimate shopping agents can trick consumers into providing payment credentials, shipping addresses, and other sensitive information to fraudsters who create convincing replicas of trusted AI shopping interfaces. Consumer verification of AI agent authenticity is technically challenging because sophisticated fraud operations can closely replicate the appearance and behavior of legitimate AI systems, making it difficult for non-technical consumers to distinguish between real and fraudulent agents. Platform operators who host AI shopping agents bear responsibility for verifying agent authenticity and monitoring for fraudulent behavior, with potential liability under both consumer protection statutes and negligent facilitation theories. The development of AI agent authentication standards, digital certificates, blockchain-verified identities, or platform-endorsed trust badges is essential to preventing fraud but raises additional concerns about market access for smaller AI developers who may lack resources to comply with certification requirements. 7.7 Open-source AI commerce protocols and regulatory frameworks. The proliferation of open-source protocols for agentic commerce including MCP, Model Context Protocol, A2A, Agent-to-Agent, AP2, ACP, and UCP creates governance challenges around who is responsible when these protocols are used to facilitate harmful transactions or enable fraud. The Linux Foundation's Agentic AI Foundation provides a governance structure for protocol development, but the open-source nature of these projects means that anyone can implement and modify the protocols, potentially introducing security vulnerabilities or removing consumer protection safeguards. Liability frameworks for open-source AI commerce infrastructure are largely undefined. When a consumer is harmed by a transaction conducted through open-source protocols, potential defendants include the protocol developers, the companies that implemented the protocols, the AI agents that used them, and the retailers that accepted the transactions. Standardization efforts face the challenge of balancing interoperability, which benefits consumers and smaller retailers, with competitive differentiation, which platform operators rely on for market advantage, creating tensions between collaborative standard setting and antitrust compliance. Security vulnerabilities in open-source protocols could expose millions of transactions to exploitation, and the decentralized nature of open-source development makes it difficult to assign responsibility for patching and maintaining security. Regulatory agencies face the challenge of overseeing commerce conducted through open-source protocols that evolve faster than regulatory processes can respond, requiring new approaches to technology-neutral regulation that focus on outcomes rather than specific technical implementations. International coordination on AI commerce protocol standards is complicated by differing regulatory philosophies. The EU's precautionary approach versus the U.S. innovation-first philosophy, creating potential fragmentation of the global agentic commerce ecosystem. 8 U.S. tariff upheaval reshapes cross-border e-commerce economics. The de minimis exemption, the $800 duty-free import threshold that allowed low-value shipments to enter the U.S. without formal customs entry, was suspended for Chinese imports on May 2, 2025, and then extended to all countries on August 29, 2025, fundamentally altering the cost structure of cross-border e-commerce. Every inbound shipment to the United States now requires formal customs entry and duty payment regardless of value, adding customs brokerage fees, formal entry processing costs, and duty calculations to transactions that previously required no customs engagement whatsoever. Section 301 tariffs on Chinese goods range from 20% to 30% depending on product category, with higher rates applied to categories including electronics, textiles, and consumer goods that constitute the bulk of cross-border e-commerce shipments. A product with a $12 FOB cost from China now carries $2.40, $3.60 in duties alone, before considering customs brokerage fees, bond costs, and formal entry processing charges. This tariff burden transforms a product with a 65% gross margin into one with a 52 to 57% gross margin before accounting for any other cost increases, materially impacting profitability for e-commerce businesses operating on already thin margins. The Supreme Court ruled IEEPA-based tariffs unlawful on February 20, 2026, finding that the International Emergency Economic Powers Act does not authorize the President to impose broad tariffs on imported goods. President Trump replaced the invalidated IEEPA tariffs with a 10 to 15% Section 122 global surcharge, which allows temporary import surcharges during balance of payments emergencies but is limited to 150 days at rates not exceeding 15%. Brands that updated their landed cost models within 90 days of the tariff changes, adjusting pricing, renegotiating supplier terms, and restructuring logistics preserved approximately 85% of pre-tariff contribution margins, demonstrating that speed of response was the primary determinant of business impact. Those that waited 6+ months to adapt saw permanent margin erosion of 8 to 15 percentage points, as competitors who adjusted faster captured market share and suppliers locked in pricing terms with more responsive buyers. Platforms like Shein and Temu, which built their business models on shipping millions of ultra-low-cost parcels under the de minimis exemption, were hit hardest by the policy changes, facing fundamental questions about the viability of their direct from China supply chains. Some brands initially shifted sourcing to Vietnam, India, and Mexico to avoid the China-specific tariffs, but the August 2025 expansion of the de minimis suspension to all countries closed that workaround, requiring formal customs entry for all international shipments regardless of origin. Section 232, National Security, and Section 301, Unfair Trade Practices, tariffs remain in effect alongside the new Section 122 surcharge, creating multiple layers of duties that can apply simultaneously to a single product importation. The practical reality for e-commerce businesses is that every international shipment now faces multiple regulatory and financial requirements that did not exist 2 years ago. Customs brokerage costs, which were zero for de minimis shipments, now add $25 to $75 per formal entry, an amount that can exceed the product cost for low-value items. The tariff landscape remains volatile, with Section 122 authority legally limited to 150 days at rates up to 15%, creating uncertainty about what happens when that authority expires and whether new tariff mechanisms will be imposed. Businesses face fundamental uncertainty around whether existing tariffs will be extended through alternative legal authorities, modified through trade negotiations, or challenged through additional litigation. Cross-border e-commerce volumes have measurably declined for ultra-low-cost direct from China retailers, with some analysts estimating 20 to 35% volume decreases for the most de minimis dependent businesses. Reshoring and nearshoring conversations are accelerating among mid-market brands, with Mexico and Central America emerging as preferred nearshore manufacturing alternatives that reduce transit times and tariff exposure. The pricing decision between absorbing duties entirely, passing the full cost to consumers, or implementing a split impact approach varies significantly by product category, price sensitivity, and competitive positioning. Consumer goods, electronics, and textiles face the highest Section 301 rates, creating the greatest pricing pressure in categories that constitute the bulk of online retail sales volume. Supply chain diversification has evolved from a cost optimization exercise into a strategic imperative, with companies investing in multi-country sourcing, bonded warehouse strategies, and foreign trade zone utilization to manage tariff exposure. Legal subtopics. 8.1 Supreme Court IEEPA Tariff Ruling and Constitutional Trade Authority. The Supreme Court's February 20, 2026 ruling that tariffs imposed under the International Emergency Economic Powers Act exceed the scope of presidential authority represents a landmark decision in the constitutional allocation of trade power between the executive and legislative branches. The court's opinion held that while IEEPA grants broad authority to impose economic sanctions in response to national emergencies, the statute's text and legislative history do not authorize the imposition of tariffs, which the Constitution explicitly reserves to Congress under Article I, Section 8. This separation of powers ruling limits the executive's ability to use emergency declarations as a mechanism for imposing trade barriers, requiring future tariff actions to rely on explicitly tariff-authorizing statutes such as Section 201, Section 301, Section 232, or Section 122 of the Trade Act. The legal basis for the Section 122 replacement surcharge is itself subject to constitutional scrutiny, as the statute limits emergency import surcharges to 150 days at rates not exceeding 15%, and the executive's characterization of trade imbalances as balance of payments emergencies is contested by trade lawyers. The ruling created immediate compliance questions for importers who had been paying IEEPA-based duties, including whether they could seek refunds for duties paid under what the court determined was an unlawful program. International trade partners reacted to the ruling with a mix of relief and uncertainty, as the decision constrains one tool of presidential trade policy while leaving intact others, including Section 301 tariffs that trading partners consider equally problematic. The long-term constitutional significance of the ruling extends beyond trade to the broader question of executive emergency powers, establishing precedent that may limit presidential authority in other domains where emergency declarations have been used to justify expansive executive action. 8.2 To minimize exemption suspension and small business impact. Legal challenges to the de minimis exemption suspension have been filed by trade associations representing small businesses, e-commerce platforms, and international shipping companies, arguing that the suspension exceeded the executive's authority under Section 321 of the Tariff Act of 1930. The Section 321 restoration advocacy effort includes a coalition of small business groups that argue the de minimis exemption was specifically designed to reduce customs processing costs and burden for low-value shipments, and that its suspension disproportionately harms small sellers who lack the infrastructure and expertise for formal customs entry. Small business coalition lawsuits emphasize that formal customs entry requirements including HTS classification, duty calculation, and customs broker engagement impose fixed costs that are economically devastating for businesses shipping individual low-value items, as the administrative cost may exceed the value of the goods. The compliance burden is particularly severe for small e-commerce sellers who previously shipped directly from overseas suppliers to U.S. customers without any customs interaction, and who now must either engage customs brokers, obtain importer of record credentials, or restructure their entire supply chain. Congressional proposals to restore the de minimis exemption with modifications such as reducing the threshold to $200 or $400 rather than eliminating it entirely represent potential legislative solutions that would balance customs enforcement goals with small business protection. The economic impact studies commissioned by trade associations estimate that the full suspension of de minimis has eliminated approximately 500,000 small business import transactions per day and added billions in aggregate compliance costs to the U.S. economy. Administrative burden quantification shows that formal entry requirements add an average of 2 to 3 business days to shipment clearance times, eliminating the speed advantage that enabled many small e-commerce businesses to compete with domestic inventory holding retailers. 8.3 Section 301 Tariff Compliance and Customs Enforcement. Section 301 Tariff Compliance requires importers to correctly classify products under the Harmonized Tariff Schedule, HTS, and apply the appropriate tariff rate, a process that has become increasingly complex as tariff lists have expanded and product classifications have been disputed. HTS classification disputes arise when products fall near the boundary between tariff categories with different duty rates, and importers have the right to seek binding rulings from U.S. Customs and Border Protection, CBP, but may face delays of months before receiving a determination. Penalty avoidance requires importers to demonstrate reasonable care in their classification and valuation practices, a standard that CBP evaluates based on the importer's systems, expertise, documentation, and responsiveness to CBP inquiries. Customs audit defense is a specialized practice that involves responding to CBP's focused assessments and compliance examinations, which can cover years of import transactions and result in penalties that include both liquidated damages and civil fines. Prior disclosure programs allow importers who discover compliance errors to voluntarily notify CBP before an audit identifies the issue, typically resulting in reduced penalties and demonstrating the good faith that CBP considers in assessing enforcement responses. The expansion of Section 301 tariff lists has created classification challenges for products that incorporate components from multiple countries, as the country of origin determination affects which tariff rate applies and whether specific exclusions are available. E-commerce importers face particular challenges because they often import a high volume of diverse products with varying classifications, making it difficult to maintain the detailed classification records that CBP requires for compliance. 8.4 Cross-border e-commerce and international trade agreements. U.S. tariff actions have raised questions about compliance with World Trade Organization, WTO, commitments, as WTO members are generally bound to tariff schedules that limit the maximum duty rates they can impose, and unilateral tariff increases may violate these bound rate commitments. Bilateral trade agreement implications vary by country. The USMCA, United States-Mexico-Canada Agreement, provides duty-free treatment for qualifying goods originating in North America, but complex rules of origin requirements determine whether products assembled in Mexico or Canada with Chinese components qualify for preferential treatment. The USMCA's rules of origin analysis requires detailed documentation of where components were sourced, where manufacturing processes occurred, and whether sufficient transformation took place to confer North American origin, a compliance exercise that can be prohibitively complex for small e-commerce businesses. WTO dispute settlement proceedings initiated by trading partners challenging U.S. tariff actions could take years to resolve and, even if successful, may not result in tariff removal if the U.S. declines to comply with adverse rulings, as has occurred in previous trade disputes. Free trade agreements with countries including South Korea, Australia, Singapore, and Israel provide reduced or zero duty rates for qualifying products, creating opportunities for e-commerce businesses to optimize sourcing strategies around preferential trade arrangements. The proliferation of digital trade provisions in modern trade agreements, including rules on cross-border data flows, source code protection, and digital product non-discrimination, creates a separate layer of trade law compliance that interacts with traditional tariff obligations. E-commerce businesses must navigate the intersection of tariff law and digital trade rules, ensuring that their cross-border operations comply with both the duty requirements on physical goods and the regulatory frameworks governing the digital transactions through which those goods are sold. 8.5 Tariff classification and product misclassification penalties. False classification enforcement by CBP targets importers who intentionally or negligently assign incorrect HTS codes to their products in order to reduce duty payments, with penalties ranging from the value of the merchandise to 4 times the revenue lost by the government. CBP's penalty mitigation guidelines distinguish between different levels of culpability: negligence, gross negligence, and fraud, with each level carrying progressively more severe financial penalties and, in fraud cases, potential criminal prosecution. Voluntary self-disclosure programs offer importers who discover classification errors the opportunity to report them to CBP before an audit, typically resulting in substantially reduced penalties and demonstrating the compliance culture that CBP considers in future enforcement decisions. The classification challenge for e-commerce products is particularly acute for multi-component items, such as a product that combines electronics, textiles, and plastic components, where the essential character determination that drives classification may be genuinely ambiguous. AI-powered classification tools are emerging to help importers assign HTS codes, but the legal responsibility for classification accuracy remains with the importer regardless of what technology was used to determine the code. Post-entry amendments allow importers to correct classification errors after goods have been entered, but CBP imposes time limits on amendments and may assess penalties if the errors reflect systemic compliance failures rather than isolated mistakes. The financial stakes of misclassification are significant. Section 301 tariff rates on Chinese goods range from 7.5% to 30%, meaning a classification error that shifts a product from one tariff category to another can result in duty underpayments of thousands or millions of dollars across a high-volume import program. 8.6 Import surcharge legal challenges and administrative law. Section 122 of the Trade Act of 1974 authorizes temporary import surcharges of up to 15% for a maximum of 150 days during periods of large and serious balance of payments deficits, and the current administration's use of this authority is being challenged on the grounds that the statutory conditions have not been met. Administrative Procedure Act, APA. Judicial review allows affected parties to challenge the surcharge in federal court, arguing that the agency action was arbitrary, capricious, or contrary to law, a standard that requires the government to demonstrate a rational basis for its determination that a balance of payments emergency exists. Industry group legal challenges filed by the National Retail Federation, U.S. Chamber of Commerce, and other trade associations seek to enjoin the surcharges on the grounds that Section 122 was designed for genuine macroeconomic emergencies, not as a general trade policy tool. The 150-day statutory limitation creates a temporal constraint that distinguishes Section 122 surcharges from the open-ended authority available under Section 301 or Section 232, and importers are watching closely for whether the administration will attempt to extend the surcharges beyond the statutory period. If courts determine that the Section 122 conditions were not satisfied, importers who paid surcharges could be entitled to refunds through the customs duty refund process, potentially creating billions of dollars in government liability. The overlap between Section 122 surcharges and existing Section 301/232 tariffs raises questions about whether the combined duty rates are effectively confiscatory, particularly for products that face tariff stacking from multiple authorities applied simultaneously. Constitutional scholars are debating whether the cumulative effect of multiple overlapping tariff authorities, each individually within legal limits, creates an unconstitutional burden on commerce that exceeds what any single statute was designed to permit. 8.7 Cross-border consumer protection and international returns. Duty drawback provisions under 19 U.S.C. 1313 allow importers to recover up to 99% of duties paid on goods that are subsequently exported or destroyed, including goods returned by consumers, but the drawback process requires detailed record keeping and involves processing times that can extend 12 to 18 months. Consumer rights in cross-border transactions are complicated by the fact that duties paid on imported goods are typically embedded in the purchase price, and consumers who return products may not receive a full refund if the seller retains a portion of the price to cover non-recoverable duties and customs fees. Chargebacks on tariff-affected purchases present unique challenges when consumers dispute charges that include tariff pass-through amounts, as payment processors must determine whether the tariff-related portion of the price was properly disclosed at the time of purchase. Cross-border return logistics involve reverse customs processes that can be more complex than the original importation, requiring return authorization, re-export documentation, and coordination with customs brokers to ensure duty drawback eligibility. Consumer protection laws in the buyer's jurisdiction may require the seller to absorb tariff costs associated with returns, creating a financial burden that discourages cross-border e-commerce and effectively functions as a non-tariff trade barrier. The Federal Trade Commission's Mail and Internet Order Rule requires sellers to offer full refunds for returned goods, and the interaction of this requirement with non-refundable customs duties creates compliance tension for cross-border merchants. International harmonization of consumer protection standards for cross-border e-commerce remains limited, with significant differences between US, EU, and Asian consumer protection frameworks creating a fragmented legal environment that raises costs and reduces consumer confidence in cross-border purchases. 9 E-commerce cybersecurity threats surge as supply chain attacks and AI-powered breaches escalate. Supply chain attacks, AI-enhanced breaches, and major corporate security incidents defined the cybersecurity threat landscape for e-commerce in early 2026, with attacks growing in both sophistication and financial impact. Researchers uncovered malicious campaigns targeting SAP NPM packages that were designed to steal developer credentials, potentially giving attackers access to enterprise systems used by thousands of companies for supply chain and inventory management. A critical flaw discovered in Google's Gemini CLI allowed remote code execution in continuous integration/continuous deployment (CI/CD) environments, threatening the software development pipelines that power e-commerce platforms. A hard-coded API key in the ClickUp JavaScript client exposed enterprise and government email addresses for over a year before being discovered, highlighting the persistent risk of credential leakage in widely used productivity tools. A WordPress plugin with over 70,000 installations was found to contain a dormant backdoor that had been present for years, representing a supply chain compromise that could have affected tens of thousands of e-commerce stores running on WordPress and WooCommerce. Microsoft SharePoint faced a zero-day vulnerability, CVE 2026-32201, affecting over 1,300 servers, with particular risk to e-commerce companies using SharePoint for internal collaboration and document management. The average data breach cost reached $4.44 million according to IBM's 2025 Cost of Data Breach report, an amount that can be existential for small and mid-market e-commerce businesses. E-commerce platforms face mounting threats from credential theft, ransomware targeting fulfillment and logistics systems, and payment skimming malware that intercepts credit card data during the checkout process. Verizon's 2026 Data Breach Investigations Report, DBIR, found that the human element encompassing phishing, stolen credentials, social engineering, and human error remains the top breach vector, involved in approximately 60% of all data breaches analyzed. It takes companies an average of 241 days to identify and contain a data breach, during which time attackers can exfiltrate customer data, payment credentials, and proprietary business information. European authorities dismantled a €50 million cryptocurrency fraud network that used fake investment platforms indistinguishable in design from legitimate e-commerce sites to defraud consumers across multiple countries. Ukrainian police took down a hacking ring that had hijacked 610,000 Roblox accounts worth approximately $225,000, demonstrating that virtual goods and gaming economies are increasingly targeted alongside traditional e-commerce. Robinhood disclosed an account creation flaw that allowed attackers to send phishing emails from legitimate company email addresses, a vulnerability type that is particularly dangerous in e-commerce where email is a primary communication channel for order confirmations and shipping updates. The gaming, cryptocurrency, and e-commerce sectors are prime targets for organized cybercrime because they combine high transaction volumes, valuable personal data, and payment credentials in a single attack surface. The Verizon 2026 DBIR highlights that generative AI is augmenting both attack and defense capabilities, creating an accelerating arms race between cybercriminals who use AI to craft more convincing phishing emails and social engineering attacks, and defenders who deploy AI for real-time threat detection and response. Organizations are urged to enforce multi-factor authentication, MFA, across all systems, eliminate hard-coded secrets and API keys from code bases, and isolate build environments from production systems to prevent supply chain compromises from reaching customer-facing applications. Plugin audits and integrity checks are critical for e-commerce platforms running WordPress and WooCommerce, as compromised plugins represent one of the most common entry points for attackers targeting online stores. The FTC's 2026-2030 strategic plan explicitly prioritizes privacy and data security enforcement, signaling that companies suffering data breaches due to inadequate security measures will face regulatory consequences in addition to the direct costs of the breach. The statistic that 60% of breaches involve a human element underscores the importance of security awareness training, phishing simulations, and organizational culture in preventing breaches that technical controls alone cannot stop. E-commerce companies must invest in zero-trust architectures and real-time threat monitoring systems that assume every access request is potentially hostile and verify identity and authorization continuously. The cost of cybersecurity failure extends far beyond financial penalties and remediation expenses to encompass brand destruction, customer trust erosion, and long-term revenue impact that can take years to recover from. Legal subtopics. 9.1 Data Breach Notification Laws and E-commerce Compliance. All 50 U.S. states, the District of Columbia, and U.S. territories have enacted data breach notification laws with varying requirements for notification timing, content, regulatory reporting, and the types of personal information that trigger notification obligations. State-by-state notification requirements range from 30 days, Colorado, to 60 days, most states, to most expedient time possible without unreasonable delay, California, creating a compliance matrix that e-commerce companies must navigate when a breach affects customers in multiple states. The FTC has established that failure to maintain reasonable data security measures constitutes an unfair practice under Section 5, and the Commission has brought dozens of enforcement actions against companies that experienced breaches resulting from inadequate security. The SEC's 2023 cybersecurity disclosure rules require public companies to report material cybersecurity incidents within 4 business days on Form 8K, creating an accelerated disclosure timeline that may conflict with the longer notification periods allowed by state law. Notification content requirements vary by state but typically include a description of the incident, the types of information affected, steps taken to address the breach, and information about identity theft protection services offered to affected individuals. The cost of compliance with breach notification laws, including forensic investigation, legal analysis, notification production and delivery, credit monitoring services, and regulatory reporting, adds significantly to the direct financial impact of the breach itself. E-commerce companies must maintain incident response plans that are pre-coordinated with legal counsel, forensic investigators, and notification vendors to ensure compliance with the shortest applicable notification deadline across all affected jurisdictions. 9.2 E-commerce PCI DSS compliance and payment security. The Payment Card Industry Data Security Standard, PCI DSS, version 4.0, which became mandatory in March 2025 with additional requirements phasing in through March 2026, imposes comprehensive security controls on any entity that stores, processes, or transmits cardholder data, including e-commerce merchants of all sizes. PCI DSS compliance requirements are tiered by transaction volume. Level 1 merchants, over 6 million annual transactions, must undergo annual on-site assessments by a qualified security assessor, while smaller merchants may complete self-assessment questionnaires but remain subject to the same substantive security standards. Liability for card data breaches is allocated through the payment card brand operating regulations, which allow card brands to impose fines on acquiring banks for merchant non-compliance, and those fines are typically passed through to the merchant, creating financial exposure that can reach millions of dollars. The distinction between merchant responsibility and processor responsibility for payment security is governed by contractual agreements and PCI DSS's shared responsibility matrix, but in practice, a breach affecting cardholder data typically generates liability for multiple parties in the payment chain. New PCI DSS 4.0 requirements include enhanced authentication for administrative access, targeted risk analysis for security controls, and automated technical mechanisms to detect and prevent web-based payment skimming attacks. E-commerce platforms that host multiple merchants including Shopify, BigCommerce, and WooCommerce hosting providers bear compliance obligations at the platform level that affect all merchants using their infrastructure. The financial consequences of PCI DSS non-compliance extend beyond fines to include increased transaction processing fees, mandatory security remediation audits, and potential loss of the ability to accept card payments, a consequence that is effectively a business death sentence for e-commerce companies. 9.3 Ransomware payments and legal implications. E-commerce companies facing ransomware attacks that encrypt critical systems including order processing, inventory management, and customer databases must navigate complex legal questions about whether paying the ransom is legally permissible, strategically advisable, and properly disclosed. The Office of Foreign Assets Control, OFAC, has issued advisories warning that ransomware payments to sanctioned entities or sanctioned countries may violate U.S. sanctions laws, even if the victim company does not know the attacker's identity or nationality. FBI guidance generally discourages ransomware payments on the theory that payments fund criminal enterprises and encourage future attacks, but the FBI acknowledges that individual victim organizations must make their own business decisions based on their specific circumstances. Cyber insurance coverage for ransomware payments is increasingly contested, with insurers implementing coverage caps, requiring specific security controls as conditions of coverage, and adding exclusions for payments to sanctioned entities. The legal question of whether a ransomware payment constitutes a material cybersecurity incident requiring SEC disclosure creates reporting obligations that publicly traded e-commerce companies must consider in their incident response planning. Some jurisdictions have proposed or enacted legislation prohibiting ransomware payments by government entities, and there is ongoing debate about whether similar prohibitions should extend to private sector organizations in critical industries. E-commerce companies must document their ransomware response decisions thoroughly, including the business justification for any payment, the sanctions screening performed, and the law enforcement notifications made, to defend against potential regulatory scrutiny after the incident. 9.4 AI-enhanced cyber attacks and evolving legal frameworks. AI-powered phishing attacks that use large language models to generate contextually appropriate, grammatically flawless, and highly personalized phishing emails have dramatically increased the effectiveness of social engineering attacks against e-commerce companies and their employees. Deepfake fraud prosecution under existing criminal statutes including wire fraud, 18 U.S.C. 1343, computer fraud, CFAA, and identity theft faces challenges because the statutes were drafted before AI-generated synthetic media existed, creating ambiguity about whether AI-generated impersonations constitute the false pretenses or fraudulent representations these laws require. The Computer Fraud and Abuse Act, CFAA, the primary federal statute for prosecuting cybercrime, is being reconsidered by Congress to address AI-enhanced attacks, with proposals to increase penalties for attacks that use AI tools and to criminalize the development and distribution of AI tools specifically designed for cyber attacks. AI-powered vulnerability discovery tools enable attackers to identify and exploit software vulnerabilities faster than human security researchers can patch them, creating a temporal advantage for attackers that is particularly dangerous for e-commerce platforms that process financial data. Legal responses to AI-enhanced cyber attacks must balance the need to prosecute malicious use of AI with the protection of legitimate AI security research, which also uses AI tools to discover and report vulnerabilities. International cooperation in prosecuting AI-enhanced cybercrime is complicated by jurisdictional boundaries, with attackers often operating from countries that lack extradition agreements or adequate cybercrime legislation. The evolving legal framework for AI-enhanced cyber attacks will likely require new statutory authorities that specifically address the use of AI in criminal conduct, updating a legal framework that was designed for a pre-AI threat landscape. 9.5 Third-party vendor and supply chain security liability. E-commerce companies that suffer data breaches originating in third-party vendor systems face complex liability questions about the allocation of responsibility between the company, which has a direct relationship with affected consumers, and the vendor, which operated the compromised system. Contractual liability for vendor breaches is typically governed by the service agreement between the company and its vendor, which may include indemnification clauses, limitation of liability provisions, and specific security requirements, but the enforceability and adequacy of these provisions are often tested only after a breach occurs. SaaS provider security obligations have received increased regulatory attention, with both the FTC and state attorneys general examining whether companies that outsource data processing to cloud providers retain primary responsibility for the security of the data entrusted to them. Indemnification disputes following vendor-related breaches frequently lead to litigation, as the breached company seeks to recover its losses, including notification costs, regulatory fines, litigation settlements, and reputational harm from the vendor whose systems were compromised. The proliferation of vendor relationships in e-commerce, including payment processors, shipping APIs, marketing platforms, analytics tools, and customer service software, creates an attack surface that extends far beyond the company's own systems. Vendor risk management programs, which assess and monitor the security posture of third-party providers, are increasingly viewed by regulators as a minimum requirement for reasonable security, and failure to implement such programs can support claims of negligent vendor selection. Supply chain security frameworks such as SOC 2 Type 2 reports and ISO 27001 certifications provide evidence of vendor security practices, but these point-in-time assessments may not detect ongoing vulnerabilities or reflect the vendor's actual security posture at the time of a breach. 9.6 E-commerce platform liability for customer data loss. Class action exposure for e-commerce companies that experience data breaches affecting customer information has increased significantly, with plaintiffs' attorneys developing increasingly sophisticated theories of harm that overcome the standing challenges that previously limited breach litigation. Statutory damages under state privacy laws provide a floor for recovery that does not require proof of actual harm. CCPA/CPRA allows statutory damages of $100 to $750 per consumer per incident, which can aggregate to billions of dollars in class actions involving millions of affected customers. EU GDPR fines can reach up to 4% of global annual revenue or €20 million, whichever is greater, and European data protection authorities have demonstrated willingness to impose near maximum fines against large companies that fail to implement adequate security measures. The FTC's authority to impose civil penalties for unfair or deceptive security practices has been strengthened by the Health Breach Notification Rule and the Commission's use of consent decrees that impose decades-long compliance monitoring and reporting obligations. Negligence claims against e-commerce platforms require plaintiffs to prove that the company's security measures fell below the standard of care expected in the industry, a determination that often involves expert testimony about security best practices and the specific vulnerabilities that led to the breach. The causation element in breach litigation, proving that the company's security failures, rather than some other factor, caused the plaintiff's injuries, is being addressed through legal theories that shift the burden of proof to the defendant once a security failure and data exposure are established. Insurance coverage for data breach liability is increasingly critical, and e-commerce companies must carefully review their cyber insurance policies to understand coverage limits, exclusions, self-insured retentions, and the specific types of claims and costs that are and are not covered. 9.7 Cyber insurance coverage and e-commerce risk management. Cyber insurance policies for e-commerce companies typically cover first-party costs, forensic investigation, notification, credit monitoring, business interruption, and third-party liability, legal defense, settlements, regulatory fines, but policy terms vary significantly between insurers and coverage gaps are common. Policy exclusions for state-sponsored attacks, often referred to as war exclusions, have become a major coverage concern following attribution of several high-profile cyber attacks to nation-state actors, as insurers argue that state-sponsored attacks fall outside the scope of commercial insurance. Coverage disputes between policyholders and insurers have increased as cyber insurance claims have grown, with common points of contention including whether the insured met the security requirements specified in the application, whether the attack type falls within a covered peril, and the calculation of business interruption losses. Premium increases averaging 20 to 50% annually for e-commerce companies reflect insurers' increasing loss experience and the growing frequency and severity of claims, creating a cost burden that is particularly significant for small and mid-market online retailers. Risk assessment requirements imposed by cyber insurers including MFA implementation, endpoint detection, backup testing, and vulnerability management effectively function as de facto security standards, as companies that cannot meet these requirements face either unaffordable premiums or outright denial of coverage. The cyber insurance market is maturing with more standardized policy forms and clearer coverage definitions, but significant inconsistencies remain between policies from different insurers, making broker expertise essential for securing adequate coverage. E-commerce companies must treat cyber insurance as one component of a comprehensive risk management strategy that also includes security controls, incident response planning, vendor risk management, and business continuity capabilities. Insurance alone cannot prevent breaches or eliminate the reputational and operational harm they cause. 10 FTC Consumer Protection Enforcement reshapes e-commerce privacy and platform accountability. The FTC published its 2026 to 2030 strategic plan outlining enforcement priorities focused on consumer protection through enhanced privacy and data security oversight, signaling a new era of regulatory activism targeting e-commerce platforms and digital marketplaces. Currently operating with only 2 commissioners out of a full complement of 5, the plan's ambitions raise questions about the Commission's capacity to execute its enforcement agenda, though the plan prioritizes high-dollar harm cases that maximize impact with limited resources. The strategic plan targets 5 core areas: deceptive practices in digital commerce, unlawful privacy and data security conduct, big tech accountability for harm to children, worker protection against surveillance and algorithmic management, and unfair ticket sales practices. The plan explicitly aims to deter harmful practices, without unduly burdening legitimate business activity, language that attempts to balance enforcement vigor with recognition that overly aggressive regulation could stifle e-commerce innovation. Enforcement mechanisms include consumer fraud reports submitted through reportfraud.ftc.gov, law enforcement partnerships with state attorneys general and international regulators, and the Commission's own investigative authority. Success measures outlined in the plan include money returned to consumers through enforcement actions, injunctive orders that stop unfair practices, and compliance improvements achieved through rulemaking and industry guidance. The plan signals continued aggressive enforcement against e-commerce deception, with particular focus on AI-driven practices that the existing regulatory framework addresses incompletely. Social media scam losses are 8 times higher than in 2020, according to FTC data, reflecting the explosive growth of social commerce fraud that coincides with the rise of platforms like TikTok Shop and Instagram Shopping. The Commission issued consumer alerts about job offer text scams and social media fraud on April 27 to 30, 2026, highlighting the agency's use of public awareness campaigns alongside formal enforcement actions. The FTC's focus on high-dollar harm suggests that priority cases will target the largest e-commerce players: Amazon, Meta, Google, TikTok, rather than smaller companies, concentrating enforcement resources where the impact on consumer welfare is greatest. Big tech accountability for children's online safety is a central pillar of the strategic plan, reflecting bipartisan political support for protecting minors from harmful content, addictive design patterns, and unauthorized data collection on platforms they use for shopping and social interaction. The Commission is actively exploring how AI-driven recommendations and automated decision-making affect consumers, including whether algorithmic pricing, personalized advertising, and AI-curated product selections create unfair or deceptive outcomes. Privacy and data security remain the top consumer protection goal across all three of the plan's strategic objectives, with the Commission treating data protection as foundational to all other consumer protection work. The understaffed Commission's ability to execute the ambitious plan remains an open question, with former FTC officials noting that two commissioners cannot even form a quorum for certain enforcement votes without adopting special procedures. E-commerce companies face an increasingly complex patchwork of federal and state privacy regulations that create overlapping, and sometimes conflicting, compliance obligations. Proposed federal privacy legislation modeled on the American Data Privacy and Protection Act, ADPA, continues progressing through congressional committees, with key debates centering on federal preemption of state laws, private right of action provisions, and the scope of exemptions for small businesses. State laws including CCPA/CPRA, California, VCPA, Virginia, CPA, Colorado, TPA, Connecticut, and newer laws in Texas, Oregon, Montana, and Utah create a compliance maze where each state imposes different consent requirements, consumer rights, exemptions, and enforcement mechanisms. The FTC's Deception and Unfairness Authority under Section 5 provides broad enforcement power that the Commission can apply even in the absence of specific privacy legislation, as demonstrated by decades of enforcement actions against companies with inadequate privacy practices. Companies must design privacy programs proactively aligned with FTC priorities including data minimization, purpose limitation, and robust security measures to minimize the risk of enforcement actions that can result in consent decrees lasting 20 years and fines exceeding $100 million. The convergence of AI, privacy, and consumer protection creates unprecedented compliance challenges, as companies must simultaneously satisfy AI transparency requirements, privacy obligations, and consumer protection standards that were not designed to work together. E-commerce businesses that proactively address these challenges implementing privacy by design, AI transparency measures, and robust security programs will gain competitive advantage through enhanced consumer trust and reduced regulatory risk, positioning themselves favorably as the regulatory environment continues to tighten. Legal subtopics. 10.1 FTC Section 5 Enforcement against e-commerce deceptive practices. The FTC's authority under Section 5 of the FTC Act to prohibit unfair or deceptive acts or practices provides the Commission's broadest enforcement tool, applicable to virtually any commercial conduct that causes substantial consumer injury, is not outweighed by benefits, and could not be reasonably avoided by consumers. Recent consent decrees against e-commerce companies have imposed penalties ranging from millions to hundreds of millions of dollars, along with mandatory compliance programs, independent assessments, and decades of regulatory monitoring. Dark pattern enforcement targeting website and app designs that trick consumers into making purchases, subscribing to services, or sharing data they did not intend has become a central focus of Section 5 enforcement, with the FTC issuing staff reports identifying specific dark pattern categories. Subscription trap cases, where companies make it easy to subscribe but deliberately difficult to cancel, have generated some of the FTC's largest enforcement actions, with the Commission seeking both consumer redress and civil penalties. The FTC's penalty authority was significantly enhanced by recent legislative action restoring the Commission's ability to seek monetary penalties in federal court under Section 13(b), reversing the Supreme Court's 2021 decision in AMG Capital Management v. FTC that had limited the Commission's remedial powers. Consent decree compliance monitoring imposes ongoing costs on companies subject to FTC orders, as they must implement comprehensive compliance programs, retain independent assessors, and file regular reports demonstrating continued adherence to order requirements. The deterrent effect of FTC enforcement extends beyond the companies directly targeted, as industry observers and compliance officers use FTC enforcement actions as benchmarks for acceptable business practices across the e-commerce sector. 10.2 Federal Privacy Legislation Status and E-commerce Impact. The American Data Privacy and Protection Act, ADPA, and successor bills represent the most significant attempt at comprehensive federal privacy legislation, with provisions covering data minimization, purpose limitation, individual rights, and accountability obligations that would apply to all e-commerce businesses. Preemption of state privacy laws is the most contentious issue in federal privacy legislation, with industry groups strongly supporting federal preemption to create uniform national standards, while California and other states with strong existing privacy laws argue that federal legislation should set a floor rather than a ceiling. The private right of action debate whether individuals should be able to sue companies directly for privacy violations or whether enforcement should be limited to government agencies significantly affects the legislation's impact on e-commerce companies, as private litigation creates substantially greater financial exposure than government enforcement alone. Business compliance requirements under proposed federal privacy legislation include mandatory privacy impact assessments, data protection officer appointments, algorithmic impact assessments for automated decision-making systems, and civil rights impact assessments for high-risk data practices. Small business exemptions in proposed legislation attempt to reduce compliance burden for small e-commerce sellers, but the specific thresholds, typically based on revenue, data volume, or both, determine which businesses qualify and have been subject to extensive lobbying. The legislation's treatment of sensitive data including precise geolocation, biometric information, genetic data, health information, and financial data creates heightened obligations that are particularly relevant for e-commerce companies that collect such data through payment processing, delivery, and personalization features. The timeline for federal privacy legislation remains uncertain, with optimistic observers projecting passage within the current congressional session and skeptics noting that privacy legislation has been debated for over a decade without reaching the president's desk. 10.3 Children's Online Privacy and COPPA Enforcement in E-commerce. The Children's Online Privacy Protection Act, COPPA, prohibits the collection of personal information from children under 13 without verifiable parental consent, and the FTC's 2024 updates to the COPPA rule expanded the definition of personal information and strengthened the requirements for parental consent mechanisms. Age verification technologies including age estimation based on facial analysis, credit card verification, government ID upload, and knowledge-based authentication each have limitations in accuracy, privacy implications, and user friction, creating challenges for e-commerce platforms that must determine which users are under 13. Parental consent requirements under COPPA mandate that e-commerce sites obtain verifiable consent before collecting, using, or disclosing children's personal information, with the FTC accepting specific consent methods including signed forms, credit card verification, and video conferencing verification. State child privacy laws extend beyond COPPA's scope. California's Age-Appropriate Design Code Act requires data protection impact assessments for features that children are likely to access, creating obligations for e-commerce platforms that sell products appealing to minors even if those platforms are not specifically directed to children. The FTC has brought major COPPA enforcement actions against technology companies with penalties exceeding $170 million, establishing that inadequate age verification and unauthorized data collection from children carry severe financial consequences. E-commerce platforms that sell children's products face particular COPPA risk because the nature of their merchandise may establish that the platform is directed to children, triggering COPPA obligations that apply to all users of the site regardless of their actual age. The interaction between COPPA, state children's privacy laws, and general consumer protection law creates a multi-layered compliance framework that requires e-commerce companies to implement comprehensive children's privacy programs spanning data collection, parental consent, data security, and deletion. 10.4 FTC Negative Option Rule and Subscription e-commerce. The FTC's updated Negative Option Rule, finalized in 2024, establishes comprehensive federal requirements for subscription businesses including clear disclosure of material terms, express informed consent before charging, and simple cancellation mechanisms requirements that apply to all subscription e-commerce businesses regardless of size. The click to cancel requirement mandates that companies provide cancellation mechanisms that are at least as easy to use as the method the consumer used to subscribe, prohibiting practices like requiring phone calls to cancel a subscription that was started online. Auto-renewal disclosure mandates require companies to clearly and conspicuously disclose the automatic renewal terms, cancellation policy, and total cost of the subscription before obtaining the consumer's consent, with the disclosure placed immediately adjacent to the consent mechanism. Enforcement actions against subscription traps have resulted in some of the FTC's largest consumer protection settlements, with penalties reflecting the aggregate harm caused by millions of consumers who were unable to cancel unwanted subscriptions. The rule's prohibition on dark patterns specifically addresses design techniques that obscure cancellation options, require excessive steps to complete cancellation, or deploy guilt-tripping messaging, "Are you sure you want to miss out?" intended to discourage consumers from exercising their cancellation rights. Compliance requires subscription e-commerce companies to redesign their checkout flows, customer account interfaces, and cancellation processes, with implementation costs that are particularly burdensome for smaller companies that lack dedicated compliance teams. State automatic renewal laws, including California's ARL, which served as a model for the federal rule, continue to apply alongside the federal requirements, and in some cases impose additional obligations such as pre-renewal notification and post-cancellation confirmation that exceed the federal standard. 10.5 State privacy laws and multi-state e-commerce compliance. The proliferation of state comprehensive privacy laws, with California, CCPA/CPRA, Virginia, VCPA, Colorado, CPA, Connecticut, TPA, Utah, UCPA, Texas, TDPSA, Oregon, OCPA, Montana, MPA, and additional states enacting legislation annually creates a compliance challenge that some legal experts describe as the most complex regulatory environment in U.S. business history. Each state law varies in its definition of personal data, the rights granted to consumers, the obligations imposed on businesses, the thresholds for applicability, the enforcement mechanisms, and the available exemptions, making standardized compliance across all states extremely difficult. Consumer rights vary significantly. CCPA/CPRA grants the most expansive rights, including a private right of action for data breaches and opt-out rights for automated decision-making, while Utah's law provides more limited rights and imposes fewer obligations on businesses. Consent requirements differ by state, with some laws using an opt-out model. Consumers must affirmatively request that their data not be sold or shared, and others requiring opt-in consent for processing sensitive personal data, creating different default rules that businesses must implement simultaneously. Enforcement mechanisms range from exclusive attorney general enforcement, most states, to private right of action, California, for data breach claims, with significant differences in penalty amounts, cure periods, and the availability of injunctive relief. Data protection impact assessments are required by several state laws for high-risk processing activities, including targeted advertising, profiling, and sale of personal data, creating documentation obligations that must be maintained and updated on an ongoing basis. Compliance strategies for multi-state e-commerce operations typically involve either implementing the strictest standard, California, nationwide, or building a compliance framework that dynamically adjusts based on the consumer's jurisdiction. Each approach has trade-offs between operational simplicity and competitive flexibility. 10.6 FTC endorsement guides and e-commerce reviews/testimonials. The FTC's updated endorsement guides, effective in 2024, establish comprehensive requirements for how e-commerce companies use customer reviews, influencer testimonials, and expert endorsements in their marketing, with particular attention to the transparency of material connections. Fake review crackdowns have accelerated, with the FTC proposing rules that would impose civil penalties for procuring, selling, or disseminating fake reviews, and for using undisclosed insider reviews or review suppression tactics. Material connection disclosure requirements extend to any relationship that might affect the credibility of an endorsement, including employment relationships, free product provision, contest entries, business partnerships, and even family relationships between the endorser and the company. Penalties for endorsement guideline violations include civil penalties of up to $50,120 per violation under the FTC's Penalty Offense Authority, which the Commission has used to put companies on notice that specific practices violate established FTC precedent. The FTC's enforcement focus on review gating, the practice of soliciting reviews only from customers likely to leave positive feedback, addresses a widespread e-commerce practice that the Commission views as creating misleadingly positive review profiles. Third-party review platforms, Trustpilot, Bazaarvoice, etc., face their own liability for hosting or distributing fake reviews, and their verification and fraud detection practices are subject to FTC scrutiny. E-commerce companies must implement comprehensive review and endorsement compliance programs that include training for marketing teams, monitoring systems for user-generated content, disclosure templates for influencer partnerships, and regular audits of review solicitation practices. 10.7 AI-driven personalization and consumer protection. Algorithmic pricing fairness. The practice of using AI to set different prices for different consumers based on their predicted willingness to pay raises consumer protection concerns under both the FTC's unfairness doctrine and emerging state laws that specifically address automated pricing discrimination. AI discrimination claims arise when personalization algorithms produce disparate outcomes based on race, gender, age, or other protected characteristics, even when the algorithm does not explicitly use those characteristics as inputs, a concept known as proxy discrimination or algorithmic bias. Automated decision-making transparency requirements are expanding through both legislation, EU AI Act, proposed U.S. federal privacy law, and regulatory guidance, FTC policy statements, requiring companies to explain the logic of their AI systems and provide consumers with opportunities to opt out or contest automated decisions. The EU AI Act's impact on e-commerce extends beyond European operations. Any AI system used in connection with products or services offered to EU consumers must comply with the Act's requirements, regardless of where the AI system was developed or deployed. Personalized pricing that uses consumer data including browsing history, location, device type, and purchase history to set individualized prices may constitute an unfair practice if consumers are not informed that prices are personalized and do not have an opportunity to access a non-personalized price. The use of AI to curate product selections and filter search results creates a curation liability if an AI system systematically excludes products from certain categories, brands, or sellers. Affected parties may have claims under competition law or platform fairness regulations. Consumer protection in the age of AI personalization requires a balance between the genuine benefits of personalized shopping experiences, relevant recommendations, time savings, discovery, and the risks of manipulation, discrimination, and information asymmetry that AI systems can create when designed to maximize platform revenue rather than consumer